Everybody, please rise and come down as 9 session Honorable Bill Ryan preside.
Let's take the pledge this morning, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. All right, good morning, everybody. As you recall, the jury's going to come in this morning at 10, so we'll undertake to hear first from the defense witnesses concerning their desire to introduce some extrinsic evidence concerning the witness of Bo Duke's conduct. So, I understand we were looking for 4 people today. Is that right?
We've got the lead officer here.
Right.
And so we are not going to call Ashley Day or Amanda Eisner.
Okay.
2 other incidents. We spoke with them last night, and they very much desire not to testify.
Okay.
We've made the decision that we're not going to put them through that. But we do have Officer Delshorno for the Houston County indictment.
Okay.
Thank you.
All right.
So just to clarify, the indictment number we were given yesterday does not relate to, I believe, Officer Delshorno. So I just want to be clear that we're talking about, I guess, if I can have an incident date of when the event occurred in 2017 or 2019, because the indictment number we were given relates to a 17 case, and Officer Delshorno worked a 19 case.
17 case against Mr. Dukes.
It occurred in 17. It wasn't indicted. Both of them occurred indicted in 19.
Yes, not a problem. So for some reason, the indictments list have the same number, both indictments, that he had a 2017 rape.
Go ahead. I'm just going
Yeah, no, of course.
They're 2 different indictment numbers. Well, they are, so you sent us, you just have it out of order.
To split this witness, are your other witnesses, Ms. Merchant, are they connected with the case this gentleman's going to testify about?
No.
Okay. Let me ask you to stand up and raise your right hand for me, please. Thank you. You swear or affirm the evidence you're going to provide in the hearing of this case will be the truth, whole truth, and nothing but the truth, so help you God.
I do, sir.
Good. Thank you so much. Please be seated. Thanks for coming down this morning.
Yes, sir.
Ms. Merchant, you can proceed.
Thank you so much, Judge. And just to answer the state's question, this is the 2019 rape allegation. There's a 2017 rape allegation as well, but I don't believe Officer Delshorno had any involvement in that.
Correct. Thank you.
Great, thank you. Did you swear the witness, Judge? I'm so sorry. I thought you did. Okay, thank you. Officer, will you state your name for the record?
Detective Tyler Delshorno with the Warner Robins Police Department.
Great, thank you.
Delshorno. Delgiorno. Yes, sir.
Thank you. Did you have an occasion to get involved in a case, or how did you get involved in a case involving Bo Dukes?
So on the 1st of January 2019, I was the on-call detective for the city of Warner Robins. I was called out to the scene of the report of a rape that occurred within the city limits.
And tell me about what you learned in your investigation.
So being the on-call investigator, I was called out by the patrol supervision to take over the investigation. Officers responded to the scene of 301 Charlestown Way in reference to 2 women reporting that they were assaulted at this location.
I'm going to need testimony from the officer related to hearsay about what anyone said to him specifically as it relates to the 2 women reporting something that obviously would be hearsay.
Just for the purposes of this proffer, we are just introducing it for purposes of the proffer. We're not introducing it in front of the jury. And so
The only thing that the jury would hear, of course, is that there's a pending case.
Right.
Right.
Well, they would hear the pending case, and there's some other things about the flight that this officer can testify to about how Mr. Dukes essentially led the police on a manhunt and had to be located, so evidence of flight. But for purposes of the proffer, and typically, most of the time proffers are given by the state in a 404B, and the proffers are almost always a summary of the police interrogation and the police investigation. And so in this case, that's exactly what we're doing. It's the same as...
Yeah, I've done a number 404B.
I'm sure, yes.
But I don't do them with summaries. I like to hear from the witnesses that are going to present it. They can tell you that. So whatever competent testimony he can give, that's what we'll go for.
Great, thank you, Judge.
Thank you. That's sustaining your objection, Ms. Hart.
Can you tell us who was alleged to have committed a crime?
And Judge, I'm going to object.
I didn't ask what anybody said.
Any allegation of a crime occurring based on the questions she asked is going to be related to what someone told them. She hasn't asked him who was indicted or who he took warrants
Just
against.
ask him who he's indicted. I sustain that objection.
Thank you.
Did you appear in front of the grand jury?
I did.
And who did you indict, or who did you present for indictment in this case?
Bo Dukes.
And what charges did you present for indictment?
I don't have the indictment in front of me, but the warrants that I sought were rape, aggravated sodomy, false imprisonment, and possession of firearm by convicted felon.
And did you arrest Mr. Dukes, or were you involved in arrest warrants being issued?
I did not, I was not present during his apprehension. I sought the warrants. The Marshals Fugitive Task Force took over the search for him, and they apprehended him.
Can you tell us the status of the case now? Have you been called to testify?
For my particular case, no ma'am, it's still pending prosecution.
Okay. Did you testify in front of the grand jury?
I did.
Okay. Can you give us a summary of what you testified to in front of the grand jury?
And Judge, I'm going to object because that would call for hearsay.
Judge,
And hearsay's allowed at grand jury.
and when we're not in front of the jury, it's allowed as well. For a proffer, it is allowed. Hearsay is allowed for a proffer.
But, Matt, sorry.
I sustain your objection.
Did the grand jury render an indictment
Yes, ma'am.
on the charges that you stated?
Yes, ma'am. Well, I don't know specifically what they rendered. I didn't see the final true bill, but I believe so, yes, ma'am.
Okay. The charges that you testified about, without telling us what someone told you, what charges do you recall testifying about?
From my recollection, the rape, false imprisonment, aggravated sodomy, and possession by convicted felon, of a firearm by convicted felon, is my
Okay.
recollection.
And you did charge the firearm. Without telling us what someone told you, did your investigation reveal that there was a firearm involved?
Yes, ma'am. We did collect one on scene.
You collected one on the scene?
Okay, thank you. I couldn't hear you.
Yes, sir, I'm sorry.
You collected a firearm on the scene.
Yes, sir, I did.
Thank you.
Was
The police
Mr.
department did.
Was Mr. Dukes on the scene?
He was not. At the time of my arrival, he was not.
Or did you ever get an opportunity to interview him?
I attempted to. I spoke with Mr. Dukes. He invoked his constitutional rights, and I did not continue the interview after that.
Just one moment. Sure. Thank you. Nothing further. Thank you.
All right. Any questions?
I think just two. Officer, you don't, and I'm sorry, what's your title? I apologize, I missed it.
Detective.
Detective, sorry. Every agency I've ever worked with is different. Detective, you don't currently know the whereabouts of Ashley Weiss, who I think now may be Ashley Day, do you?
Ashley Weiss is deceased.
Okay. And you don't currently know the whereabouts of Carrie Tidwell?
I do not.
And Carrie Tidwell is the only living victim listed in this indictment, is that right?
Yes, ma'am.
Okay. And at the time...
Well, I assume she's living. I haven't had contact with her since this incident.
Okay, so
Since the investigation.
So that was going to be my next line of questioning is, at the time of the investigation back in 2019, is Carrie Tidwell the listed victim who failed to show up for her follow-up investigation? Or her follow-up interview, I should say.
She made it clear that she didn't want to go back over the incident.
Okay.
I wouldn't so much say that she failed to show up. She indicated to me that she didn't really want to cooperate following the initial interaction.
And I guess maybe I'm confused, but was there not a time in which you scheduled an interview the next day to speak with the two victims, or at some point in the next few days to speak with the two victims?
Yes, ma'am. For investigations of this nature, I typically have an initial interview and then follow-up interviews, depending on the nature of the circumstances and each particular victim, whether or not they want to do the second.
Okay.
And she did not want to.
And is my understanding, or is it correct, that at the time that you attempted to have that second interview, Carrie Tidwell had warrants pending for her arrest?
That's my recollection, yes, ma'am.
And just to clarify, you said you've not had any contact with her, I guess, since 2019?
I don't know this last specific date. I was working like a go-between with the victim's advocate at the Crossline Safe House. I don't know when the advocate may or may not have spoken to her, so I can't speak to a specific, but it's been several years, yes, ma'am.
Thank you, that's all the questions.
Can we follow up on that?
Yeah. Yes, thank you. Did you have an opportunity to review video footage in this case?
Yes, ma'am.
What did you see on the video footage?
So there are multiple different footages of different vantage points of different locations.
Okay.
So I reviewed footage from the suburban inn up in Macon, where the two victims in the case initially advised that they were picked up. I reviewed
And sorry, apologize to interrupt you. For purposes of the proffer, I'm not objecting him testifying about what's on the video, but I don't want to waive the right to object to that in front of the jury. Obviously, it would be improper without video. But I apologize. I don't object right now.
Judge, it's still not improper without the video. He can testify as to what he viewed on the video.
We'll
Thank
get
you.
to that, but if you're not waiving anything, Ms.
Thank you, Judge.
Go ahead.
Please continue.
Yes, ma'am. It was at the Suburban, it was a bit of a distance, so there wasn't clear detail, but what appeared to be the two victims in this case, as they described it to me, they were leaving with their luggage, and a white male arrived in a white vehicle, looked like a smaller SUV, which matched the description of what Mr. Dukes had in his possession from his girlfriend. And the two women entered the vehicle with the luggage and then left the scene, again, which was consistent with the investigation up to that point.
Did you view any other footage?
Yes, ma'am. I watched footage from a neighbor where the initial outcry was made. They fled the initial incident location to a neighbor's residence to request help and to call 911. I reviewed that footage. I saw two females, one unclothed, one partially clothed, frantically running up to the front of it was a home surveillance system kind of facing the front of the residence, and making contact with the resident and requesting a call to 911, which again was consistent with what I'd been told and what I knew up to that point.
Did you have an opportunity to review the 911 tapes?
Yes, ma'am.
And tell us about those.
It was the documentation of the initial outcry to 911. Again, it was
What was the initial outcry to 911?
of a sexual assault, of being held against their will, of being threatened. There was, I could tell that they were emotional, that they were, it was unusual, the tone of their voice, something inconsistent with a normal conversation. I can't really speak to what they were thinking at the time, but that was my impression.
And without telling me what they said, did you speak with neighbors and the people that were on video that the girls fled to?
I did.
Any other videos that you were able to review?
Other than, documenting my interviews that were recorded,
Did you interview Brooke Sheridan?
I did.
Was she at the scene?
At the time of my arrival, she was, yes, ma'am.
Whose home was it? The scene.
Hers, but he lived there. He was a resident of the home.
So Ms. Sheridan was there when you arrived, but Mr. Dukes was not?
Correct.
Okay, thank you.
Any further, Ms. Hart?
Yes, sir. Sorry, it's very different cross-examining an officer. Are you familiar with whether or not the listed victims in this case had any prior criminal history?
Objection relevance.
Just the particular criminal history they had would be relevant as it relates to the allegations of rape.
No, it wouldn't.
I sustain that.
The hotel in which you saw the video footage, are you familiar with that hotel? Were you familiar with that hotel before that night?
I'm not familiar with its location. That was in Bibb County, within the city of Macon.
Okay.
I work in Warner Robins. I've been to some restaurants and businesses near there. I had no dealings with that to my recollection prior to this incident, that hotel.
So since that is not your jurisdiction, you're not familiar with that hotel being one that is frequented by prostitutes?
Judge, I'd object. This is protected by Rape Shield. And prostitutes can be raped.
I agree, prostitutes can be raped. A prostitute is crime.
Sustain that.
Did you actually go into the residence?
Yes, ma'am.
And in the residence, you found the luggage of the two females?
Yes, ma'am. There was items inside. Yes, ma'am.
And those items?
So by the time of my arrival, most of their property had been collected and taken with them in the garage. I spoke with the officers that initially responded. They said that prior to them collecting them together, their items were in the house.
And that being the items of the Miss Tidwell and Miss Weasel, or Wessel?
Ms. Weiss, yeah, that's my understanding, yes, ma'am.
Okay. And there were no items of those two persons left in the vehicle that you saw them picked up in, is that correct?
That's not correct. I'm confused. You're asking, were there items in the vehicle that I believe Mr. Dukes was in that picked him up? Is that what you're asking?
Yes, I'm asking, at the time that the police were called, had they left any items in the vehicle?
They said they had. The vehicle was not on scene. Mr. Dukes was gone. We later seized it following, subsequent to his apprehension. I did a search warrant. We searched it and we found some items belonging to Mr. Dukes.
Okay, you did find some. What items did you find belonging to them?
I have to go through my inventory. I believe some writings, clothing that I believe belong to them.
Okay. The clothing, was it in luggage bags or were the luggage bags in the house?
Both, I believe. I was not the officer that actually executed the search warrant. Our crime scene investigator did that.
Okay.
I only understood from speaking to him following and then reviewing the photos. So specific where he found it and what order he found it, I can't speak to.
Okay, thank you. No further questions.
Thank you. So all of this information that you've talked about here today, did you share that with the district attorney?
Yes, ma'am. They've reviewed my case file as well as, speaking person to person. Yes, ma'am.
And they chose to present this case to the grand jury for indictment?
Yes, ma'am.
Thank you.
Okay, Detective Del Giorno, is that right?
Yes, yes.
All right, sorry. Thank you for your testimony. You can step down. Let's talk about this act, because I understand the other witnesses are not related to this.
Right.
All right, why should this come?
So, and can I just clarify that for the record, because I know there was some confusion as to who Ashley Day is, and so I just wanted to make sure that that was clear for the record. Judge, Ashley Day is not Ashley Wees. Ashley Wees and Carrie Tidwell are both the alleged victims in this indictment that Officer Del Giorno was testifying to. And
And those are the ones you said you talked to last night, and they just don't want to be here, right? Isn't that what you told me this morning?
two of them, but not
These two.
Yes, well, let me go through, can I go through the separate incidents, because it gets confusing.
Obviously, I'm confused. Go ahead, sure.
So the first thing I wanted to clarify is that Ashley Day is not Ashley Wees. This indictment, and so I'm just going to talk about this case and give the information on this case. So this case is indictment, and the cover sheet to the indictment had the wrong number on it, so I want to put the right number in the record. It's a 2019 case. The indictment number is 2019-C-53334. It's a Houston County indictment for rape, aggravated sodomy, another count of aggravated sodomy, and there's two victims for the aggravated sodomy. One is Ashley Wees, one is Carrie Tidwell. Kidnapping, another count of kidnapping for each. Aggravated assault with a deadly weapon for each victim, and possession of a firearm both during the commission of a felony and by a convicted felon. So Officer Del Giorno investigated those cases. As far as those cases, I believe that they're relevant for a couple different purposes. To show in this case, one thing that my client testified to is that he was scared of Bo Dukes. And the jury, one of the things they have to determine is his credibility. Whether or not he was scared of Bo Dukes, this goes towards that. It shows that.
What competent evidence does? I mean, he can't testify about what the lady said.
He can testify about the flight. So Ashley Wees is deceased, so she cannot testify, unfortunately. But there's evidence, there's a video that can be admitted that is competent evidence that they actually ran naked they climbed out a window. They were picked up by Mr. Dukes, and then they climbed out of a window screaming and crying to a neighbor's house and then called 911. 911 calls are admissible. So those are non-testimonial when the alleged victim calls 911 and makes a statement. They said on the 911 call they were sexually assaulted. We do not want to put Ms. Tidwell through having to testify if we can avoid it. And so I just don't want to do that. But there's competent evidence outside of her testifying. There's competent evidence that is able to be, and admissible evidence.
Well, let's talk about that.
The video.
The video of the fleeing.
The video of the fleeing, and also the neighbors.
And Mr. Dukes shown in that video where they're fleeing.
He's shown picking them up, and then they climb out of his house. And so you can see them going in, and then you can see them jumping out the window and running naked to a neighbor. I've also interviewed the neighbors. The neighbors are under subpoena. They can testify as to what the girls said, and that's, I'm sure, how the state would be presenting the case,
How can they testify to what the girls said?
because it's non-testimonial. The girls said what happened in the case, and one of the girls is deceased. And so it's the same thing as the 911. So let's say we take the neighbors out of it, and we just bring the 911 call in. The 911 call is enough. It says that they were sexually assaulted by Mr. Dukes. It says they were held at gunpoint. It says they were sodomized. Then we've got the flight. We've got Mr. Dukes fleeing the jurisdiction. That's indicia of guilt. That's an indicia of guilt in any and every case. The state's allowed to present evidence of flight to show guilt, and that's what we would be showing. We would be showing evidence of flight. He was not only fleeing from this case, he was also on bond in the Ben Hill case, and so he violated that bond by fleeing. So one of the things that we should be able to present it for is to show the evidence of flight, Judge. And so that's for the Houston County case. But then also he's got another case. It also shows bias because they're pending charges. The district attorney's office in Houston County has these charges, and he has not been brought forward to answer for them.
I was looking back over the transcript from when we addressed this about 30 days ago, maybe. We discussed a lot about that then. That requires Mr. Dukes to testify, though, doesn't it? As we discussed in that hearing.
No, Judge, it doesn't, because he has given statements to the police, and some of those,
Your position's different than now, right?
that he said, well, back then we didn't know what he was going to do.
And did he testify?
We didn't know what he was going to do. So I still think it shows bias because he has given evidence to the state. He is the reason that they knocked on Ryan Duke's door. So he's the reason. So it still shows bias for those reasons. Then we've got the second, for the record, I want to go over the second indictment as well. And
Involving these ladies.
no.
All right, let's talk about this.
Okay, you want to take it one at a time?
Yeah, let's take one at a time. Thank you, Ms. Hart. Any argument as to their admissibility in this case under 404B, inverse or reverse, whatever you call it, and the bias statute under 608?
Yes, Your Honor, I was just trying to make sure, I was checking my discovery from defense counsel before I went any further. Make sure I was telling you correctly. A couple things, Judge. One, as the 404B, reverse 404B, that's what you want me to
Whichever you
answer?
want to do, 608B or 404B, whichever. They're asking for it to be admitted under both.
Okay, so I'm going to start with bias because I think that's the easiest one. I understand defense counsel's position has been the whole time that Bo Dukes is somehow related to the state, even though we put him in prison. That being said, what is important, if we're going to put evidence in front of the jury, is that it be relevant to the jury's determination if any bias exists. It doesn't matter if the court or even defense counsel or the state believes he's biased. The question is whether or not the jurors can hear competent evidence as it relates to whether or not this witness is biased, and therefore
Based on
provide.
pending charges unrelated to this.
Correct. As the court has pointed out, he in fact has not been a witness for the state. We did not introduce a single shred of evidence of anything that he has said that is inculpatory of Ryan Duke. We took painstaking efforts to make sure that did not occur. Defense counsel is the one who introduced Bo Duke's statements into this case through their client. The defense counsel is the one that put him on the stand, and he offered no testimony whatsoever in front of this jury. There is absolutely no relevance as it relates to bias. Even if there could be an argument made that a pending charge in a different circuit somehow shows bias, that's irrelevant to this case because the only purpose of bias is to show the testimony can't be believed.
I agree with you. Tell me about the video.
Judge, we've never been served the video. That's what I was looking at. They're talking about putting in a video and a 911 call. We've never been served those things. So if they have those and those exist, we would be arguing that that's a discovery violation. I'm looking at the discovery that was served just recently, 5-1. That's what I was checking to make sure.
Let's say you got it in one of those 40 boxes you got. I'm talking about its admissibility.
It's admissibility. Judge, again, when you start talking about a 404B, you would have to show that it's relevant for a purpose other than propensity evidence. They have not shown that. Even though notice is not required for defense counsel, as it relates to the fact that it still has to be admissible for a proper purpose. There is zero evidence other than that from the defendant.
Well, I mean, it's all propensity, I mean, that's what she's saying.
404B doesn't allow propensity evidence.
But that's why they wanted it, sounds to me like, to show that he's the type of person that.
That's my point, Judge, is that that's why it's not a proper 404B, because there's no, even if you could prove right, Bo Dukes was the one that committed this crime, which I would submit to you based on what they told the court, they would not be able to do. That's part of the 404 analysis. There's not a proper purpose, which is the other portion of the
Like,
404.
is that, I mean, what I understand the issue is the evidence must relate.
There's a, sorry.
Sorry.
No, it's
Look
okay.
at that mosque gate.
So with 404B, when we're doing it or when defense is doing it, there's a three-pronged test that the courts have laid out under 404B. The first, they can't even get past, which is whether or not they can prove that the defendant or present sufficient evidence that the state, the jury could believe that the defendant, or in this case Mr. Dukes, committed the crimes alleged. What they have presented to the court, even assuming that there isn't a discovery violation, is that they would put an officer on the stand to testify that he took charges, warrants against Bo Dukes, that he presented evidence to Bo Dukes, presented evidence to a grand jury on Bo Dukes, that at some point Bo Dukes was arrested on the warrants because he specifically testified he can't talk about the flight because he wasn't involved with
What do you
that.
think that means, sufficient proof to permit a jury finding he committed the extrinsic act? I mean, that doesn't mean beyond a reasonable doubt.
No,
They don't have to put that up. They have to put up something that's not related to his character.
Correct.
They have to put up sufficient proof to permit a jury finding he committed the act. And the probative value must not be substantially outweighed by undue prejudice. That is, pretty much doesn't apply when it's someone in Mr. Duke's position and not his position,
Well,
right?
403, sorry.
That's a danger when it's the defendant's stuff, right?
Well, 403 still applies to the state, but I'm not even arguing 403 because I don't think we get there. Again, we have to prove a crime. What they've submitted is that they would put up the officer to testify that he took warrants, presented an indictment to the grand jury, and that there's evidence of a person in a vehicle that he's been told matches the vehicle Bo Dukes was driving that day because it wasn't Bo's
The
vehicle.
position is, without these ladies, they can't prove it.
Correct. Look at it the other way. If the state were trying to introduce this against a defendant, we would never make it past one because the fact that they climbed out a window does not prove rape, it does not prove acts on.
You get the last say, Ms. Merchant, if you have any further on.
Just the 911 does. The 911 call is admissible, and it does prove it because they're on call.
I'm not going to rule as to this incident that is shut out in Houston County, indictment CS or C5-3334 is what I wrote down. It is excluded. It's not relevant as bias because he fails to testify, and it does not meet the criteria. There's no competent evidence the court finds that could lead this jury to a finding that the act was committed by Mr. Dukes. Let's move on to the next two.
May we release Mr. Officer?
Thank you for coming down this morning, sir.
Thank you so
Appreciate it.
much.
You big excuse.
Thank you.
All right, let's talk about the next one.
Yes, Judge, and I want to, if I may, just have a few minutes to put all this on the record. We are
Yes.
not presenting the other ones for consideration in front of the jury, but I would like to be able to state why, to preserve the record, in case that's ever questioned.
You're talking about the ones, so you're not going to present any in front of them,
Not the other ones, we're withdrawing.
but you want to put on the record, why?
Yes,
Why?
so that our reasons for not moving forward with those witnesses are noted for the record. It's outside of the presence of the jury, and
Well, that's a strategic decision, isn't it?
Right, and that's the reasons I wanted to place those reasons on the record.
I respond, Judge. She wants to play strategically why she's not calling a certain witness. That's one thing. Going into detail about these again, frankly, Judge, would only be going to doing that because there are cameras in the courtroom. Let's be real. And so I would, again, she said that it's a strategic reason. If we ever get to a motion for new trial, then that's something we can certainly question about. But at this point, the record is clear that they have made that decision strategically, and so we would ask to be able to just move along.
I'll allow it.
thank you, Judge. I'll be very brief, Judge.
Okay.
And one of the reasons I wanted to do it is because there was some confusion on who was who. There were, what's it, 1, 2? There were 5 different incidents we were trying to admit. One of them was Ashley Rose Suttles. That individual was interviewed by the GBI, and so we found out about her from the GBI. She lives out of state. She is the one that they had met. She and Mr. Dukes had met on Tinder, and then she alleged that he had raped her and reported that to the GBI. Then there was Ashley Peacock, who is now Ashley Day.
So what's your strategic reason for not?
She's out
That's what you want.
She's out of state, Judge, and so we don't have her under subpoena we don't have a certificate of materiality to have her here.
Did you ask for it?
No.
Okay, go ahead.
And I'm sorry, I know we're just putting on the record, but I can't sit here when I know, when I believe that the court, as candor to the court, that is not what she reported to the GBI. She reported a consensual relationship to the GBI. But anyway, I just can't sit here when I believe something's being stated that's not accurate to the court.
Then I'm happy to put the GBI interview into evidence. The next one would be Ashley Peacock Day. I don't believe she was ever interviewed by law enforcement. She was one who had had sex with Mr. Dukes in the orchard and had been tied up and things like that. We are not presenting her evidence. We don't think it would meet the threshold standard. The next one is Amanda Eisner. That was a sort of a rape fantasy between her and Mr. Dukes. And so we don't think that would meet the standard. And then the other one was Elizabeth Zoe Nelson, which is the one that is the victim that we talked about yesterday, but I had the indictment numbers wrong. 2019 C54265. That's the other Houston County case, the indictment for rape, aggravated sodomy, and possession of a knife during the commission of a felony, Judge. So those were the ones that, and we don't have any contact information for her. Thank you.
Okay. All right, got something last night concerning Mitchell M. Posey. Y'all ready to speak about that?
Yes, Judge.
I'll hear from Mr.
So, yes, Judge, so last night at 9 o'clock, for the first time, we got an expert report from Mitchell Posey, who apparently was contacted on February 13th, 2019 by Ms. Hart to provide opinions in this case related to false confessions. That report is 12 pages long and it cites over 15 studies that he's relying on. In addition to that, the report is replete with opinions or statements that he apparently is going to give concerning the truth or falsity of Mr. Duke's statements in his statements to the police. His opinion is that Ryan Duke did provide Agent Shadell with truthful information during the interview. In this report, and it's not clear when it was...
Do you believe that to be admissible?
No, Your Honor. His report. No, and I specifically talked to him when we met last evening about the fact that he can't say that.
So we're not, I agree with you on that there's certainly nothing admissible about his opinion as to whether Mr. Duke on the video he observed was being truthful. So,
Yeah, and Judge, I asked Ms. Hart about this before court started, and I asked her, when did he do this report? She said, well, I got it yesterday. And so, presumably it's current. And it's not just one instance where he talks about truthfulness. He goes into great detail in this, and again, I've only had since last night at 9 o'clock to look at it. But it says, research has shown that people who offer minimal resistance and confess at the beginning of the interview are usually being truthful. And so he goes on to say, this account matched information provided by Bo Dukes. That tells me that perhaps this was drafted before we argued the motion in limine related to Bo Duke's statements. I don't know. So he talks again about Ryan Duke gave Agent Shadell information that matched Bo Duke's statement. There were only 3 discrepancies. Well, that's code for false. I suspect he's going to get in here, take the witness chair, and talk to the jury about how he thinks Ryan was not telling the truth, that those are discrepancies. And he goes, in the next paragraph, he goes on to say, research has shown that confessions are more likely to be true. What this is, Judge, is a false confession expert report. And the gist of this, from start to finish, is that he's going to talk to the jury specifically about whether or not he believes, as an expert in the field of false confessions, that Mr. Duke was telling the truth or not telling the truth at various points in his interview, and he details it line by line. There's a lot of reasons why we're moving to exclude any testimony from Mitchell Posey. Judge, the first is this report, this 12-page report, is in stark contrast to the one-paragraph expert summary we got in discovery on this particular witness. Yes. I put a copy up there, Judge, I believe, if you don't have it.
Yeah, I got one on small, like print.
Yeah, may I approach, Judge?
Yeah. I mean, this is, Ms. Hart, you want to admit as rebuttal evidence to Dr. Talitsky's opinions, is that right?
The testimony, not the report, but yes, sir, the testimony.
Right. Anyway, go ahead.
So the first reason we're moving to exclude it is because the state failed to put any of this in the summary from Mitchell Posey in time to comply with the discovery statute. And that's despite us asking over and over again for a complete expert report for him. All we got until last night at 9 o'clock was that one-paragraph summary you're reading. And the gist of the one paragraph is he's going to talk about whether or not he believed Ryan during his interview, which is another reason we're going to move to exclude it. So that's reason number one. And we asked for Ms. Hart to put on the record when this report was drafted, if she knows, when she got it, and whether or not she had any role in the drafting of it, and why we didn't get this before trial. On the issue of whether or not he's actually rebuttal, that's a separate issue, Judge. Our motion in limine number 14 specifically requested that any rebuttal witness have rebuttal testimony. So if he's in rebuttal to Dr. Talitsky gave no information or testimony related to false confessions.
We never use that term.
Yes. In fact, he was specifically limited to talking about what his opinions were with regard to the psychological factors that affected Mr. Duke based on some of the interrogation techniques.
Right.
He never once commented on the veracity of Mr. Duke during that interview. So
He was all around it, but he was careful. I agree. Right. I don't think that was appropriate for him, and I don't think it's appropriate for this guy. Either way.
And so he's not rebuttal. If he's going to come in and say essentially what he said several times in his report, that false confession literature shows X, Y, and Z, I have reviewed the interview for Mr. Duke, and it doesn't match up. And I've also got experience in false confession theory. I'm able to evaluate whether he's telling the truth.
Well, it's like you said a moment ago. He did testify, it seems to me, Mr. Murphy, about the interview techniques used in that interview with your client. That is what I would call his testimony to be. Now, interview techniques, I believe, that opinions about interview techniques that conflict with Dr. Talitsky's would not be rebuttal.
That potentially, yes, Judge, but I don't think that's going to be part of what Mitchell Posey talks about. I don't know if there's anything in his one-paragraph summary that discusses that. And we strongly believe, because it's been true ever since 2019 when we talked to him, that he wants to talk to the jury about whether he believes Ryan.
I get it.
That's improper under 24-6-620.
I think it's improper for him to comment on the veracity of what came out of Mr. Duke's mouth in that interview. I agree with you.
And so that, Judge, is motion in limine number 15. That's the one you reserved ruling until we had this issue come up. So that it also, his testimony in that regard would also violate motion in limine number 15, which we did file pursuant to 24-6-620, which prevents a witness from taking the chair, talking to the jury about issues related to credibility. That is solely the province of the jurors, and he cannot talk about that. So if he's not going to talk about that, then he's not in violation of that motion. But we'd ask you, Your Honor, to rule on that specifically so that we're clear about that before he takes the stand. And again, Judge, the issue of the significance or the timeliness of the disclosure, our motion in limine number 10 specifically asked the court to exclude any testimony or evidence that was not timely disclosed to us prior to trial. And so it would also, because we've gotten a 12-page report now, at 9 o'clock at night on the last day of trial, essentially, it violates the discovery statute. And we'd again ask that it be excluded to the extent it was not disclosed in this one paragraph summary. And so for purposes of the record, Judge, I'm going to go ahead. I've pre-marked several exhibits detailing correspondence between myself and this expert back in 2019, all of which Ms. Hart is a party to. I've also printed with the transmittal emails a copy of his CV and his statement that were given to us at 9 o'clock last night. And I've also attached another copy of Mitchell Posey's one-paragraph summary, which is, until yesterday, the only information we had in writing about what his opinions would be. These are Defendants Exhibit 1 through 6. I'm not tendering them for purposes of the jurors, but tendering them as exhibits to our motions so that they will be part of the record.
All right, if we'll just let her take a look at that real quick. Sounds like very appropriate.
Your Honor, I don't object to any of that being viewed or made part of the record, except that Agent Posey's, I believe it's his work number, but it's in there, and obviously I would ask that that not be made public or that be placed under sealed or redacted in some way, so that his cell phone number he uses for work on a daily basis is not available to the general public.
Yeah, of course, Judge. Thank you for pointing that out.
All right, would you call that 4?
Yeah, that's correct.
What number is that?
Thank you, sir.
It's several numbers, Judge. I believe it starts with 2.
One through 6, Judge.
1 through 6, all right, well, you got to run through, here, let me, let's call this I'm going to call this Cozy 1 through 6, okay? So they'll be distinct from the others in the record. All right, anything further, Mr. Merchant, on this?
Yes, 2 other issues, Judge. The last argument that we have for excluding the testimony is this. If in fact he cannot talk about truthfulness of the statements, true or falsity of the statements, then what he would be testifying to is stuff related to interview techniques and that sort of testimony. That would definitely be cumulative of Agent Shadell and Agent Madison, who both testified about what happened in the interview. And that is the subject of our motion in limine number 11, which is designed to limit cumulative testimony on an issue. So since Agent Shadell has testified at length about interview techniques with Ryan, it would simply be cumulative of that, and we'd ask that it be excluded on that ground. So the final issue, Judge, again, I mentioned that he's cited several studies in his report, and he's also got a number of different things listed in his CV. As you'll see in the emails, I asked him for a CV back in 2019, and so I don't know if he created this for purposes of this case, or whether he just created it sometime after I asked him for it, but in 2019, he did not have a CV. He told me that in writing. So we just got this, and from what I can tell, in the interviews and interrogation training section of it, he's got 1 class on false...
Man, I don't have a CV, but that's one of your exhibits, right?
Yeah.
Let me see if I
It's
can...
attached to the back of the email, Judge, you were just handed. I think it's the next to the last or the last one.
It's not attached to the report, which is where I was looking for.
No, Your Honor.
It'd be towards the end, Judge. It's one of the 2. It's either 4 or 5. There you go.
That's Cozy 4. Okay.
So, Judge, on the back side of that CV, he lists interviews and interrogations training. There's several things there. And the last one, LLRMI, false confessions and contaminated statements, 2022, appears to be the only obvious one related to false confessions or false confession theory. So my understanding is that the state is going to call him, presumably sometime today. And we need time to look at whatever it is. If Your Honor is going to rule that he is allowed to testify in any shape or form, we need time to be able to review what's on his CV, get copies of these things, get copies of the studies so that we can properly cross-examine him. But again, Judge, that's only if you don't exclude him. We have several reasons why we believe he should not be allowed to testify in the first instance. Thank you, Judge.
All right, thank you, Mr. Merchant. All right, Ms. Hart, what's your plans for Mr. Cozy?
So to start with, Judge, I would point out, I know I've already said this, but just so I can address it again more clearly, Agent Cozy is very familiar with the fact that he could not testify as to whether or not he believes Ryan Duke's statement or he does not believe Ryan Duke's statement. We actually did discuss that previously in our motion in limine hearings, and I made it clear again that if we determined that we believed his testimony was necessary, that we would not ask him that and that he had been advised not to say that. He's been advised again.
Well, the classic question usually is this kind of consistent, blah, 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 consistent with a child that's been molested, consistent with truthful statements? That's not...
I don't know that I would agree that it's not appropriate, but that's not going to be the content of his testimony. So I don't think it's anything that needs to be argued at this point, I guess is what I'm saying.
One of the things I asked him was what he observed on the video, his manner of speech, anything like that consistent with somebody.
No, sir. That is not, as I had said earlier, this is not about whether you look left or right or up. That is not the content of what his testimony would be about. I want to start with, however, the argument that it somehow violates discovery that they received the report last night. Back in 2019, I haven't gone back to read the transcript, but my recollection of that is that the defense counsel argued that the state was required under the discovery statute to provide a summary on any expert that was going to testify. Frankly, I've never had that issue come up before because normally the reports we serve from the crime lab are sufficient. So I did not, at that point, had not researched the issue of summaries. The court ordered me to do summaries, so I did them as to any expert that we knew about in 2019 and what the content of that would be in 2019. Since then, however, I have had a chance to research it, and oddly enough, there is a case directly on point that says that unless and if you go back and read the statute, it's pretty clear, actually, I just missed it, the only experts that we're required to give reports for and summaries for are those who do psychological evaluations, scientific experiments, or sort of medical experiments of any nature. And the case law that interprets that is actually a case in which defense counsel got a conviction overturned. And the case specifically is a Supreme Court case from October of 2019. So this was after we were ordered to do the summaries, but it's Green v. State, 307 Georgia 171. Again, it's a 2019 case. In that particular case, the defendant had been convicted, and he had a expert they wanted to testify as it related to, I believe this one was on accident reconstruction. It was the defense's expert. Based on what was argued to be a discovery violation, he was not allowed to testify. Ms. Merchant successfully argued that, in fact, because that particular expert had not done any actual psychological examinations and had not done any actual scientific testing, that they were not required to serve those things. And the court held that was correct, and they overturned the conviction because that the judge erred in keeping out that particular expert. And I do have copies of that since I was prepared for this argument today.
All right, go ahead.
And so, Judge, that would be my submission is frankly, I don't believe we were required to submit the report to them prior to testifying at all. Given the length of the report that I was given this week, I felt that it was better to go ahead and serve it yesterday when I was meeting with Agent Posey so that they would have the time to read through it and be familiar with it before he testified. But if you look at the statute in this case, I don't believe we were actually required to serve it before he testified. However, once he got on the stand, if he had it, they'd be allowed to look at it, and that would have delayed the trial. And so that's why I went ahead and served it last night.
Okay.
And so as it relates to that idea that there's a discovery violation, Green stands for the exact opposite proposition, as does the statute. It reads very clearly, the statute does. I just frankly missed it in 2019.
All right.
Okay.
As to the topic.
The topic. So, Judge, again, I had a lengthy conversation meeting with Agent Posey last night. I would also point out, just so we're clear, this is more to the discovery stuff, but as you're aware, but just so the record's clear, Agent Posey did have a rather lengthy conversation and discussion with defense counsel back in 2019 as well. As it relates to what he would
He's been on your witness list.
Since 2019. Since we first discovered the idea that they may try to argue false confession theory, we've been speaking with him. But really, he would not be testifying on this idea of false confession theory. We've objected to that. The court's kept it out. He would be talking about interviews and interrogations. And I guess let me start by saying we're past the idea of false confession theory because we have had the defendant testify that he gave a false confession. And so false confession theory deals with, well, these things can cause a false confession. He has testified point blank that he gave a false confession, which totally changes the narrative of this trial. And so with that in mind, Agent Posey would talk about certainly things he's observed. I believe he'll testify he's watched this interview at least 10 times, maybe more than that, watched it and listened to it. He also has extensive training as it relates to interviews, interrogations, teaching, all of that. But he would talk about, and I went in with him specifically about the read techniques that the expert attempted to discuss the other day, that being minimization, assumption of guilt, and something he called confronting denials, which is actually not a read technique. The first two are minimization and maximization are read techniques, as is assumption of guilt. And he would talk about specifically how those read techniques, what they actually are, what read actually is. And then he would look at the different things, or talk to the jury about the different things that you look at
based on not just his experience, not just his training. Also
Different things you look at. What does that mean?
Sorry, I was getting there, but again, this also relates to the psychology because he has research as it relates to psychology of the Reed interview as well. The different things that you look at specifically, one of those would be the idea of corroborating the statement and why it is important to go beyond just what someone tells us to look to the physical evidence and other methods of corroboration. And he would talk about what he's familiar with in this case and the things that he saw in this case. And then specifically, he has noted, and these are pointed out in
What
the...
conclusions do you expect him to testify that leads to? What was said in the interview and what the corroborate?
I would
So what does
simply
that mean?
expect him to say that this physical evidence corroborates the statement. That's the opinion.
And that's it?
Yes, sir, as it relates to that issue. Then he has listed, there's several things, but the things that we would specifically talk about, he's listed out, for instance, 6 statements of responsibility that the defendant makes during his confession back in February of 2017. And he'll talk about, based on his training and all of that, why statements of responsibility are important as it relates to a confession and evaluating a confession, or what he'll call an interview and an interrogation. He'll talk about the difference between internal and external pressures that can be applied on someone and how those can affect someone. He'll talk about the fact he's noted 16 statements of guilt that the defendant made during his confession, and again, how that...
Do you think his testimony would be admissible absent Dr. Talitsky, just based on
His
the
confession?
defendant?
Yes, sir, absolutely, I do.
I mean, he got up and said, I lied.
Yes. Yes. And specifically as it relates to some of the statements of guilt and statements of responsibility, I would anticipate he would testify as to, frankly, Judge, that every single time the defendant mentions that he feels responsible or his mentions of guilt, he never once talks about burning the body. He always references feeling guilty or taking responsibility for murdering her. And so given the statement he has made yesterday, I absolutely believe it would be admissible even without Dr. Talitsky.
Well, but the jury can hear that for themselves. Why do they need your guy to say what he said on the video?
Because he's not just going to talk about the fact that he said it, but he's going to talk about why, as it relates to interviews and interrogations, that isn't something important to look at. They can hear him say, I feel guilty for murdering Tara Grinstead, but as it relates to the idea of what kind of questions were asked and how this interview, the course it took, why those are important. Why it's important that it says he's guilty for murdering her. He only expresses guilt for having murdered her. He never expresses guilt for burning her body. And based on his expertise, he can talk about that. This has nothing to do with mannerisms.
And you believe,
Sorry.
I'm sorry to interrupt you, but you believe that the fact that the defendant got up there and said all of that was a lie, you're entitled to put this up and say, well, this is what I observed about the...
Yes, absolutely.
Okay.
But again, that's not just what we have. We also do have Talitsky. But I do believe that if that were all we had, it would still be reasonable, yes. He will also actually talk about...
Well, I mean, if after his testimony, everything Talitsky said wasn't...
I agree.
I mean, he missed...
I agree.
Talitsky missed it, right?
But Talitsky's still there. They still put it up there, and so that means that it's still something that we need to address. Because who knows what they're going to argue in closing statement? I don't know. And so even though what the defendant said takes Talitsky completely out of it, it's still in front of the jury. So we still have to combat it as the state. And so he would talk about, again...
Is Mr. Posey here now?
He will be at 10:30, Judge.
All right, go ahead. That's all right.
He would talk about not just those things that he sees. He'll also talk about what he refers to as contamination in a interview. Again, this would go back to Talitsky, not the defendant, but Talitsky talked about the leading questions that he believed Agent Shadell asked, and those other things, the assumption of guilt, the minimization, and again, what he referred to as confronting denials. Agent Posey would talk about not just the things in this interview that indicate that that wasn't an issue, but also the things that were bad about the interview. I mean, there were things that he will refer to as contaminating the interview. And so you have to take that out in your analysis of the interview, because You can't, for instance, one of the things we'll talk about, and we've talked about quite a deal, relates to the disposal of the purse and the keys behind the dumpster. Even back in 2019, when he spoke with defense counsel, Agent Posey, he's actually now, I apologize, he's actually Inspector Posey now, but he talked about the fact.
What, is he with an agency?
He's
now?
with the GBI.
He's with the GBI? Okay.
He's an inspector with the GBI now. And so he will talk about that if the entire interview went this way, then I would have concerns that, for instance, assumption of guilt was causing problems with the interview. And obviously, I'm not stating it the way he would, but I've made notes about what he told me last night.
You mean Shadell's presumption of guilt?
Correct.
Is that what you're saying?
Yes, Your Honor.
He would comment
Yes.
on, not his?
Correct. That because I didn't ask Agent Shadell that I recall about his techniques at all. Because again, it's the state's position.
she
this wasn't
did.
read. She asked
Presumptive-
him about it. Presumptive guilt.
Presumptive guilt.
And he'll even talk about, like I said, at least one specific time when there is contamination in this interview, but show the difference between that and the other portions of the interview he's pointing out. And that is not something that the jury could necessarily, a lay person would understand the difference between the two, because yes, you can hear how a question's asked, but they don't understand the science behind why it's important to ask a question one way versus another way. Why one way shows guilty knowledge and the other way doesn't show guilty knowledge. And so that's what he would be talking about. He would also talk.
4. In which room? The bedroom. I'm going to show you a document that will be marked Pennington Exhibit 8. There's a base number Pennington 5. Do you recognize this photograph, Ms. Pennington? Yes. Did you take this photograph? Yes. You see that on the left side of what I assume is the mattress and the comforter, there appears to be something on the bed. Is it possible to zoom in? Sure. You see in the picture there appears to be something on the bed? Yes. This is something that was already there when you found the bed? I don't remember seeing that before. It's not something that you put on the bed, right? No. And you don't know what that is? No. I believe you already testified that the next day Ms. Heard was going on the James Corden show, right?
Defendant claimed that they were all acting weird, and then he found out Bo said that, told him that he murdered them.
So those are all directly rebutted to his
Those
testimony.
3 are to the defendant's statement, yes, sir.
All right.
And the other 3 are just for the car portion, which also technically rebuts him as well as the other witnesses they put up.
All right.
Judge, one more thing on Mr. Posey. Can we request that the court ask the state rather, to get us copies of whatever he's referenced on his CV, whether it's training materials or it's any of these publications that we would have been entitled to subpoena and get copies of if we'd known about this CV in advance?
If y'all have it, I don't know if you have it. If he brings some with him,
Yeah, we have some of the studies. I don't know that we have his materials from his trainings. But we have the studies because when we made him drive, or when he agreed to drive from Wilmington yesterday, we had to print them for him, so we can do that.
if you don't mind making a copy of those. All right, we'll be in recess till the jury gets here. Thank you. Okay. Well, let's leave them back there. It's so tight in here. But we won't start until 10, like we said. That'll give everybody a few minutes to get organized after this morning's hearing. All right, ladies and gentlemen, welcome back, all of you in the gallery. Of course, the jury's here this morning. We're about to get started. Thank you so much for your conduct and your refraining from distractions and the like. So I appreciate you doing the same today. Thank you so much. Both sides ready for the jury?
Yes, Judge.
All right. Ask the jury to join us, please. Okay. Welcome back, ladies and gentlemen. I hope you enjoyed your extra hour of relaxation this morning, hopefully. Let me tell you sort of where we are. I anticipate and would be surprised if we didn't finish the evidence today, okay? Now, sometimes it doesn't work out as predicted. These things are pretty fluid. Remember, I'm the guy that sent you home one afternoon last week. But I would be surprised if you didn't get all the evidence by the end of the day. If that in fact happens, we will adjourn at that time, come back in the morning for the closing arguments of the attorneys in the charge of the court. And at that time, the first 12 of you would be segregated out and asked to begin your deliberations in the case, okay? So we'll just see how it goes today, but that's what I anticipate happening, all right? So, we left off yesterday, ladies and gentlemen. The defense had put up some witnesses. Any other evidence from the defense, Ms. Merchant?
No, Judge, the defense closes.
The defense closes. Thank you. Ms. Hart, any rebuttal evidence? Or Mr. Rigby, excuse me.
That's okay. Yes, Your Honor. The station on Garland Lot.
All right, thank you. Ladies and gentlemen, let me tell you, the defense obviously has closed their evidence. Both parties have a right to call what's called rebuttal evidence, which is now the state has the right to call some witnesses to rebut or dispute the things the defense presented, and it's limited to those matters, okay? Thank you. Good morning, sir. Morning. Mr. Lott, is that right? All right, before you're seated, sir, please give your attention there to Mr. Rigby. He'll administer the oath.
You'll raise your right hand. Do you solemnly swear from the testimony you're about to give before the court in this case to be the truth, the whole truth, and nothing but the truth, so help you God? I do. Right, you have a seat.
Please be seated. Mr. Moore?
No, thank you. If you'll introduce yourself to the jury, please, sir.
I'm Garland Lott.
And if you'll spell your first and last name for the court reporter, please.
Garlan, Lott, L-O-T-T.
And Mr. Lott, how old are you?
37.
And are you employed?
I am.
How are you employed?
I'm employed at MDI.
And what is MDI?
Modern Disposal Incorporated. We specialize in thermoplastic compounding.
And how long have you been employed with MDI?
July will be 15 years.
Mr. Lott, do you know the defendant in this case, Ryan Duke?
I do.
And how did you know Mr. Duke?
We were high school friends.
And do you also know Bo Dukes?
I do.
How did you know Bo Dukes?
Oh, we were acquaintances in high school.
Now, the fact that you knew Ryan Duke and Bo Dukes, where did you attend high school?
Irwin County High School.
And did Ryan Duke and Bo Dukes both attend high school with you?
They did. They were a year older than I was.
And what year did you graduate high school?
2003.
When you were at Irwin County High School, did you know a teacher by the name of Tara Grinstead?
I did.
And did you ever have Ms. Grinstead as your teacher?
She taught me twice, both in history, not in 11th grade.
All right. Now, I want to direct your attention back to the time in October of 2005. Were you aware of the time when Ms. Grinstead went missing?
Yes.
And now I want to direct your attention after that. After Ms. Grinstead went missing, did you attend a party out in an orchard?
I did.
Where was this orchard that you attended a party?
It was on going towards the north side of Ben Hill County, Hudson Farms.
Had you been to the orchard or Hudson Farms prior to this particular night?
I have not.
So what was the purpose of going out there that night?
There was a party out there. Went out there just hang around by a bonfire and drink.
When you say drinking, you're talking about drinking alcohol?
Yes.
Did you know of any drug use out there that night?
I didn't know of any. I'm sure it was.
Now, at that party, was this defendant there at the party?
He was.
Bo Dukes. Was Bo Dukes there at the party?
He was.
And while you were there at the party, did you hear a comment made by those individuals about Ms. Grinstead?
I did.
What was the comment made? Where were those individuals at the time you heard this comment?
I believe they were sitting in a truck or a vehicle when the comment was made.
When you say they were sitting in the truck, who was in the truck?
Bo and Ryan were both in there.
Was anybody else in the truck?
No.
And where were you in relation to the truck?
I believe I was standing at the passenger side window.
Do you recall who was on, whether Ryan Duke was on the passenger side of the truck or Bo Dukes was on the driver's side of the
I
truck?
believe Bo Dukes was in the driver's seat
Right.
where I was in the passenger.
Now, when you were there at the passenger side of the truck, what comment did you hear made?
Well, I asked them what they thought happened to Tara, and they said that they had killed her and burned her.
Do you recall which one of them said that?
I don't recall which one said it, but the comment was, "We killed her and we burned her."
When you heard the comment, "We killed her and we burned her," what was their reaction to that? What was your reaction first?
Well, I was kind of shocked and was kind of like, well, damn, that's messed up to say. You know, and then I didn't inquire and ask any more questions about it. But I was a little shocked. It was just something that sat with me.
And what was their reaction?
They just kind of laughed, and they both laughed kind of, it was in a joking but agreeable manner.
So they laughed.
Yeah.
Both laughed.
Yes.
Thank you. Madam President.
Any cross-examination?
Yes, sir.
You don't recall which one of the two individuals specifically made the comment about killing Ms. Grinstead?
I do not.
You knew Bo and Ryan fairly well around this time, didn't you?
Yes.
Bo Dukes had a reputation for saying crazy, outlandish things, didn't he?
Yes.
He had a reputation for saying really dark things, didn't he?
Yes, he had a darker sense of humor.
Based on how well you knew the two of them, Bo was more likely of the two to have made that comment, right?
More than likely.
And if Ryan had said something like that, it really would have stood out to you.
Possibly. I mean, it stood out equally the same. Being so close to her going missing and the comment being made.
Shortly after that party, you told your roommate, Luke Roberts, about the comments you heard.
That's correct.
And within a day or so of telling Luke, you also told the folks that you worked for at the time, Andy and Janice Falk.
That's correct.
And you went to them and not directly to law enforcement because you didn't have the best reputation in Ocilla.
That's correct.
Did you think you wouldn't be believed by law enforcement?
I did.
Why did you think that?
Like I said, I didn't have a really good reputation. I was known being wild and partying a lot.
But your family matters in Ocilla with respect to how you're treated by law enforcement, right?
Can you repeat the question?
Sure. Who your family is matters with respect to how you're treated by law enforcement in Ocilla.
Maybe somewhat, but in my case, it really wasn't based on who my family was. It was just acts that I had done.
You told Andy and Janice Falk about the comments you'd heard, and that Janice wrote out a statement for you.
Correct.
You signed
It
it,
was typed out.
and once it was printed or completed, you signed it,
Correct.
and that statement was given to law enforcement shortly after you made it.
Yes.
Shortly after what? I'm sorry.
After he made the statement, after he made and signed it. You were aware around this time the GBI was investigating Ms. Grinstead's disappearance? Say yes.
Yes.
At some point after you told Andy and Janice about the statement, you actually took them out to the orchard where you were when you heard the statement.
That's correct.
And you also took a handful of law enforcement officers out there with you, didn't you?
I wanted to say a handful, but it was a few.
2 or 3?
Yeah.
And who were those law enforcement officers?
I don't remember exactly. Nelson and Alan Morgan, I don't remember.
As that Nelson Paul, was he the
Yes.
Irwin County Sheriff's deputy?
Yes.
And Alan Morgan, was he with the Irwin County Sheriff's Department as well?
Yes.
And was there an officer from Ben Hill County there as well?
I can't remember if there was or was, to be honest with you.
And so after you made this statement, you took Andy, Janice, and these law enforcement officers to the orchard.
Yes.
What did you do at the orchard?
We just went to where we were at with that party and just kind of scavenged the place, looked for a burn pile, but I don't think we was out there very long.
What time of day was it when you went out to the orchard?
It was daylight, I'm not sure at the time.
Is it fair to say that if you'd been asked at the time that you could have identified other people who were at the party who could have corroborated these statements?
If I'd have been asked at that time, yes.
And despite the fact that you gave this written statement in 2005 to law enforcement, were you ever interviewed by the GBI in this case until
I never heard
2013?
anything from law enforcement until the day they arrested Ryan.
And so the GBI never reached out to you prior to 2017 about your statement?
No.
Do you have any reason to believe law enforcement took any further steps to investigate what you told them other than going out to the orchard that one time back in 2005?
I wouldn't know if they did.
No further questions.
Yes, Your Honor. Mr. Lyon, I believe you told Janice and Andy Paul about this statement right after you heard it. Is that right?
Yes, the day after, I believe.
Now, why did you tell Janice and Andy Paul about that statement?
I was working with them at the time, and I just trusted them and knew they were very interested in the case, and thought that information would get passed along to where it needed to be.
And as a result of that, I believe you said that Janice actually wrote out a statement for you and you signed it. Is that right?
Yeah, she did a statement for me.
Now, did you give that statement directly to law enforcement, or did you give that statement to Janice?
Janice, she had the statement.
You gave it to Janice?
Yes.
Okay. But you never gave that statement directly to law enforcement?
I didn't.
Now, you also said that you went out to the orchard where the bonfire was. Is that right? Answer out loud.
Yes.
Thank you. Now, when you went out there, where was it that you went and looked?
It would probably be on the south side of that property. There was a small road next to a house with a white fence, and we went down there, and it was just to the left of the property.
Now, did y'all go way back down to the property near a pine thicket?
No.
Did you ever go back down off a logging road into a pine thicket where a clearing was?
No.
Okay, y'all just stayed right there going onto the property, just,
Yeah, probably the first clearing onto that property off of that small road.
but y'all didn't go, but you and law enforcement didn't go back anywhere back into the property?
No.
Now, I want to talk about that statement that was made again. I know that you testified was more likely Bo made it, but you don't know which one of the two made it, correct?
I don't.
But you know the statement was made,
Yes.
and you know that they both laughed about it.
Yes.
Further, any follow-up, Mr. Gibbs?
Just one. Do you know if Janice Paul turned your statement over to law enforcement?
I don't know that to be fact. She told me she did, and I believe that she did.
Nothing further.
Mr. Lott, thank you for your testimony. I'm going to excuse you at this time. You stay, go, whatever you want to do. The only thing I'll ask you, sir, is don't discuss the testimony you've given to this jury here today with any other witness in the case until it's over, okay?
Yes, sir.
Thanks so much. Have a great day.
Judge, specifically, may he be released from the rule of sequestration as well?
Any objection?
No objection.
All right, thank you, sir. Call your next witness, please.
State calls Zane Deal.
Good morning,
Come on
ma'am.
out of your sleep. Right up there.
Just stand up there.
Move this out of the way.
Before you're seated,
They're not on top of you.
we'll give your attention Ms. Hart to administer the oath and direct.
Raise your right hand. Do you swear from testimony given before this jury, the truth, whole truth, and nothing but the truth? Yes, I do. Okay, have a seat for me, please, ma'am. And can I get you to introduce yourself to any of those jurors who may not know you?
Okay, I'm Susan Luke, and I was one of Tara's neighbors.
Okay. And when you say that you were one of Tara's neighbors, let me ask you more specifically, were you a neighbor of Tara Grinstead back in 2005 when she went missing?
Yes, I was.
And in relation to the front of Tara's house, the front door, where was your house located?
This is Tara's house, and then there was Joe Portier's, and this was mine.
Okay, so you were just on the other side
Other
of the
side of
Portier?
Tara. Yes, ma'am.
And back in 2005, were you familiar with what kind of vehicle Tara Grinstead drove?
Yes.
And I know it's been a very long time, but do you recall the color of the vehicle or anything about it now?
I don't remember what year, but it was a white Mitsubishi.
Okay. And prior to her going missing, had you seen her in that vehicle?
Yes, all the time.
Now, I guess before we go any further, let me ask this. Prior to a couple days ago, did you know you were going to be testifying?
No.
Okay. So in fairness, were you watching portions of the trial before now?
Yes.
Okay. But when you became aware that you were going to testify and were subpoenaed, did you stop watching it?
Yes.
Okay. So I'm going to direct your attention specifically to the weekend that Miss Grinstead went missing. Do you recall where you were that weekend?
Yes, I was in Augusta visiting some friends. I'd left that Friday.
Okay. And when did you return from Augusta?
Sunday night, probably about 5 o'clock, 5:30.
When you arrived back that Sunday, do you recall whether or not Tara's vehicle was at her house?
Yes, it was home.
It was home. Okay. And I know you said it was about 5 o'clock, but let me ask you, do you recall if it was daylight hours when you saw her vehicle there?
Yes, it was dusk. It was probably just starting to get dark because I wanted to be home before dark.
Do you have, how do you know that that was the same weekend that Miss Grinstead went missing?
Because I had been gone when she disappeared, and when I went to work the next morning, I was called. My mother called me and told me that the GBI or the detectives were at the house and that Tara had gone missing.
Okay. That's all the questions I have. If it's helpful, may I have some questions for you?
Okay.
Ms. Merchant?
Thank you.
Hey.
Good morning, Ms. Lee.
Morning.
How are you?
I'm good. You?
Good, thank you. Do you remember talking with Agent Baudry on July 15th, 2016? Or GBI agent?
GBI. I remember talking to quite a few people, but you'd have to refresh my memory on what I said. So.
Okay, definitely.
May I approach the witness? Thank you.
Take a look at this neighborhood cannabis document, see if that refreshes your memory. You can look through it.
Okay.
The Does that help refresh your memory?
Somewhat.
So you spoke with law enforcement back in July of 2006?
Oh, yes.
And is it fair to say that your memory of the events was probably more accurate, what was that, maybe 6 months after the events than it would be now?
Yes.
And you told law enforcement that you came back Sunday night, it was around 6 or 7 p.m., correct?
Okay.
Do you remember that?
Yes.
Okay.
I knew it was close to dark, so I don't remember if it was getting dark at 6 or what time of the year the sun does this thing, but
I understand
if it was
definitely.
daylight savings time, no, I can't remember.
So just to be clear, so you did not see Ms. Grinstead's car at the house before 6 or 7 that evening?
I saw it when I got home.
Perfect. Thank you.
Having had a chance to look at that, did that refresh your recollection on whether or not it was actually before dark that you saw her vehicle?
It was before dark.
Thank you.
All right, anything else for Ms. Luke?
No, thank you, Judge.
Ms. Luke, thank you for your testimony, ma'am. I'm going to excuse you at this time, going about your business.
All right, thank you.
Have a good day. Call your next witness.
State will call Bryson Boykin. Should be in our office as well.
Good morning, sir. Just step up right there, please. Before you're seated, please give your attention there to Ms. Hart.
Would you raise your hand? Do you swear or affirm testimony given before this jury the truth, whole truth, and nothing but the truth?
I do.
Okay, have a seat for me, please, sir. And let me get you to introduce yourself to the jurors.
Bryson Boykins?
Okay, and Mr. Boykin, do you currently live in Irwin County?
No, ma'am.
However, back in 2005, where did you live?
608 South Alder Street.
Okay. Were there any other persons in that neighborhood? Let me ask this, I guess, a little differently. Did you know someone named Norman Rollins?
I did.
And did Mr. Rollins live in that neighborhood?
He kind of lived catty corner to us.
Okay. That particular neighborhood, do you recall if Tara Grinstead lived there as well in 05?
Yes, ma'am.
And were you familiar with who Ms. Grinstead was in 2005?
Yes, ma'am.
In 2005, how old were you?
14 or 15?
Okay. Excuse me, would you have had Ms. Grinstead for a teacher at that point?
No, ma'am.
And were you familiar with what vehicle Ms. Grinstead drove?
Yes, ma'am.
How were you familiar with that vehicle?
I want to say it was some type of sports car.
Okay. Had you seen her in it before?
Yes, ma'am.
Now, I want to direct your attention specifically to the weekend that she went missing. Do you recall finding out at some point that Ms. Grinstead was missing?
I personally didn't find out until Monday morning once I got to school.
Okay. And then after that, at some point, did you speak with law enforcement? The GBI?
I want to say a GBI agent came to our door and
Okay.
done an interview.
Now, in fairness, do you have any independent recollection of what happened that weekend as far as Ms. Grinstead's car?
I do not.
Okay.
No, ma'am.
Have you had a chance to read the summaries of the reports that were done based on the interviews you gave back in 2005 and they were both in 2006?
I have.
Okay. Did that refresh your recollection as to whether or not you saw Tara Grinstead's car home that weekend?
It did.
Okay. Now, I want to direct your attention specifically to Sunday.
Okay.
Do you recall if you were at home or in the neighborhood that Sunday?
I had been at my grandparents' house that weekend.
Okay.
And I got back around 2 to 4 that afternoon.
Okay. You said 2 to 4, is that what I heard you say?
Yes, ma'am.
Okay. And your residence where you were coming home to, where was that in connection to Ms. Grinstead's?
She was kind of catty corner to us also.
And do you recall whether or not Ms. Grinstead's vehicle was at her house between 2 and 4 p.m. that day?
It was.
And how do you know that it was there that day?
As we come down South Alder Street, I remember looking over and seeing it under her carport.
Okay. That's all the questions I have. Thank you.
All right, Mr. Gibbs, hang on, please. This gentleman here may have a couple of questions for you.
So you saw Ms. Grinstead's car mid-afternoon on Sunday?
Yes, sir.
You weren't at your house until then, until that afternoon?
Right.
So you can't say whether her car was there Sunday morning?
Right. I wouldn't have known.
Thank you. No further questions.
Mr. Morgan, thank you for your testimony. Now you can stand up and go on about your business.
Thank you, sir.
Have a great day, sir. Call your next witness, please.
The state would call Regina Boykin. And Judge, sorry, may Mr. Boykin be excused from the rule of sequestration?
Sure.
No objection.
You're allowed to stay here if you'd like. It's up to you. Regina Boykin, she's in our office.
Good morning, ma'am. I'm on down right here. Thank you. Before you're seated, Ms. Boykin, please give your attention to Ms. Hart there. She'll swear you in. Thank you.
Do you swear or affirm testimony before this jury, the truth, whole truth, and nothing but the truth?
I do.
Thank you. Have a seat for me.
Let me get you to introduce yourself to the jurors.
Regina Boykin.
And do you know someone by the name of Bryson Boykin?
Yes, I do.
How do you know him?
My son.
Back in 2005, where did you live?
608 South Alder Street.
And how old would your son Bryson have been at that time?
14 or 15.
Did you know Tara Grinstead?
Yes, I did.
And how did you know Tara Grinstead?
My daughter and her, she helped Lakin get ready for pageants and stuff.
Okay, and is Lakin your daughter?
Yes.
Did Miss Grinstead live near your residence back in 2005?
Yes, she did.
Were you familiar with what kind of vehicle she drove back then?
Yes, I was.
Had you ever had an occasion to see her in that vehicle?
Yes, ma'am.
Do you recall learning that Miss Grinstead had been reported missing at some point?
Not until Monday.
Monday. And on Monday, when you learned that she had been reported missing, at some point after that, were you interviewed by law enforcement?
The GBI did a phone call.
Okay. And do you recall whether or not you had seen Miss Grinstead's vehicle on that Sunday prior to you finding out she'd been reported missing?
Yes.
Okay. What do you recall about seeing her vehicle that day?
Bryson had spent the weekend with my parents.
Yes, ma'am.
And my dad brought him home. And when he got out of the truck, he started fussing because he said, Miss Taylor's at home and she'll be fussing at me for riding my lawnmower.
Okay. And when he said that, did you actually observe her vehicle in the carport?
Yes, because I told him, I said, you can't ride it.
Had you been home that entire day?
Yes, ma'am.
Do you recall ever seeing her vehicle leave her house that day?
No.
Now, to be fair, were you looking to see if her vehicle left her house that day?
No.
But do you specifically ever recall seeing it leave or come back that day?
No.
No further questions.
Mr. Gibbs.
On Sunday in question that we're talking about, do you recall what you did that morning?
I slept most of the day.
Do you recall approximately what time it was you got up on Sunday?
Probably around 2.
And that's around the same time, that Sunday afternoon, that's about the time you saw Ms. Grinstead's car?
Yes.
And so you can't say whether her car was there Sunday morning or not?
Right.
No further questions?
All right, any follow-up, Ms. Hart? Ms. Boykin, thank you for coming down here and your testimony. You're going to be excused at this time. Stay, go, whatever you want to do, all right?
Okay, thank you.
Have a good day, ma'am. Thank you. Call your next witness.
State House Cliff Benson.
sir. Just step up right there. Thanks. Before you're seated, give your attention there to Mr. Riggs.
Raise your right hand. Do you solemnly swear affirm the testimony you're about to give before the court in this case will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right, thank you. Have a seat. If you'll introduce yourself to the jury, please, sir.
I'm Clifton Benson.
And if you'll spell your first and last name for the court.
Clifton
And Mr. Benson, how are you employed?
Griffiths, Florida.
And how long have you been employed there?
Almost 2 years.
And what do you do there?
Florida.
Okay. Now, I want to direct your attention to the defendant in this case. Do you know Ryan Duke?
I do.
How long have you known Ryan Duke?
Once in middle school.
Do you know a person by the name of Bo Dukes?
I do.
And how long have you known a person by the name of Bo Dukes?
Since high school.
Do you also know a person by the name of Zane Deal?
I do.
And how do you know Zane Deal?
He's my best friend.
How long have you and Zane been friends?
Lifetime.
All right. And have you and Zane Deal ever been to a residence in Fitzgerald by the hospital where Bo Dukes and Ryan Dukes live together?
No, sir. Not that I recall.
Have you ever been to a house in Fitzgerald where Bo Dukes and Ryan Dukes live together?
No, I don't recall them ever living together in Fitzgerald.
So you've never sat on a love seat with Zane Deal and somebody else where Bo Dukes told you that Ryan Duke killed Tara Grinstead?
Not that I recall, no.
You know, you ever been to the house?
No, not that I recall, no.
Not ever happened.
Not that I recall.
Thank you. That's part of it.
Is it possible around this time period that you could have visited a home where Ryan and Bo lived and you just don't remember?
We had also had drug addiction, but I don't ever recall them living together in Fitzgerald, period.
So it's possible you could have forgotten that.
Yeah, it's possible.
Thank you. No further questions.
Anything further?
No, Your Honor.
Mr. Benson, thank you for your
Yes, sir.
testimony. You're welcome to stay, go, whatever you want to do.
No.
Call your next witness, please.
Zane Deal.
Morning, Mr. Deal. You'll step up right there. Before you're seated, if you'll give your attention there to Mr. Wrigley, please.
You'll raise your right hand. Do you solemnly swear from the testimony you're about to give before the court in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Have a seat.
Please be seated, sir.
And you'll introduce yourself to the jury, please, sir.
My name is Zane Deal. I'm 35 years old. I'm from Ocilla, Georgia. Graduated Irwin County High School in 2004. Went on to college at Boston State, graduated there in 2011. Got my master's degree from Georgia Southern in 2018 and just received my educational specialist degree in 2021.
And how are you currently employed?
I'm employed with Irwin County High School. I'm a teacher and football coach here.
All right. Now, what year did you graduate from Irwin County High School?
2004.
And as a part of being at Irwin County High School, did you know the defendant in this case, Ryan Duke?
Yes, sir.
Do you also know a person by the name of Bo Dukes?
Yes, sir.
And how did you know them from school?
Yes, sir. From school, both of those guys were 2 years older than me in high school.
And do you also know a person by the name of Cliff Benson?
Yes, sir.
And how do you know Cliff Benson?
Cliff has been one of my best friends since childhood. Thank you.
Now, Mr. Deal, I want to direct your attention back to several years ago, 2005, 2006, 2007, somewhere in that time frame. Have you ever been to a residence where Bo Dukes and Ryan Duke were living together by the hospital in Fitzgerald in a trailer?
No, sir, I have not.
Have you ever been to a house where Bo Dukes and Ryan Duke were living together in Fitzgerald?
No, sir, I have not.
Have you ever sat on a love seat with Cliff Benson and someone else and yourself where Bo Dukes told you that Ryan Duke killed Tara Grinstead?
No, sir.
Did that ever happen?
No, sir. I've never been to their house or known where they lived in Fitzgerald.
Thank you.
Any questions? Any problems? Okay.
I'm doing okay. How are you?
Good, thank you. Is it possible that you might have stopped by their trailer?
No, ma'am. I mean, to be honest with you, once all this stuff come out, somebody had to tell me where they lived at in Fitzgerald and where the trailer was located. So I didn't have a clue where it was at, and I've never been there. I'm sure I've heard about there, but I've never been inside. And never had Bo tell me the stuff that he said.
Okay. Who was your peer group then? Who did you hang out with?
I'm kind of affiliated with Bo. I think his younger brother, Jake Dukes. He's one of my best friends in high school, and so, occasionally I would, hang out with Jake, and Bo might be, there at the house, but kind of through Cliff Benson, his name was mentioned earlier, Ben McMahon, Hank McMahon, Clayton Sermons, Reese Jones. That was kind of some of our friend circle back then, but, there's many other people as well.
So you hung out with Bo Dukes through Jake Dukes?
Yes, ma'am.
Okay. Do you remember giving an interview to the police?
Yes, ma'am.
Okay. And in that interview, do you remember saying that you really didn't remember much from that time period?
Yes, ma'am.
Okay. And is there any reason that you don't remember a lot from that time period?
Well, the first time they came and see me was when I was working at Super Sets Car Wash in Boston, Georgia, while I was in college. That's when they gave me the initial saliva swab and started asking questions about that time. But I didn't necessarily know exactly what happened. I guess the weekend she went missing. I guess that's what I was referring to.
So you were friends with Cliff Benson though at this time?
Yes, ma'am.
And were you using drugs during this time?
No.
Were you arrested for using drugs during this time?
During 2007, of course.
And so it's your testimony that during 2005 you were not using any drugs? And did you also hang out with Hannah Skeen and Ben McMahon?
Yes, ma'am.
And so Ben was your roommate?
He was my freshman year of college.
Your freshman year of college. Was that October 2005?
Yes, ma'am.
That was during that
It
time?
would have been during the fall of 2004, right out of college. We lived together for the first 3 months, and then he moved back home and started going to sport day back during that spring semester.
Okay. So where would you have been living in the fall of 2005? October 2005 specifically?
The fall of 2005, I was living in a place called Blanton Commons in Valdosta, Georgia. It's an apartment complex.
Okay. And you came home once or twice a month?
Yes, ma'am. Probably something like that.
Okay. And Blake Sermons, you said that he was your friend as well?
Yes, ma'am.
Do you remember on the day that Ms. Grinstead went missing, do you remember watching a game with Blake that afternoon?
Yes, ma'am. I recall that instance.
And then speaking with Philip Luke as well?
Yes, ma'am.
And you all actually went over to Ms. Grinstead's house that afternoon, correct?
Yes, ma'am. We went over there I think I was hanging out at Philip Luke's house, and I believe if I remember right, that she was keeping Jared Luke's dog, Philip's brother, and me and Philip just rode right down the road. He lives right down the road from here, and we went and picked up Jared's dog and then took it back to their house.
So it was you, Philip, Blake, and Benja all picking up the dog?
I believe it was just me and Philip Luke that went and picked up the dog.
So you don't believe that Blake was with you?
No, ma'am. I know Blake wasn't with me. I'm about positive it was just me and Philip Luke that went and picked up the dog.
And do you remember leaving to go to a bar at that point?
That night, from what I recall, and from looking at some statements that I've had before, I believe me and a few people were at Blake Sermon's house watching the Georgia football game that Saturday.
Okay. Nothing else, thank you.
Any follow-up? Mr. Deal, thank you for your testimony, sir. You're welcome to stay, go, whatever you would like to do. Have a good day. Call your next witness.
Yes, Judge. So our next witness is the one that's going to be a bit lengthier. You had indicated you might want to take a break before we call him to the stand.
That suits you?
Yes, Judge.
All right, give us a few minutes, ladies and gentlemen. Y'all can get some fresh air. Those of you who would like to, otherwise, you'll adjourn to the jury room. Thanks. Okay, great. About 15 minutes, okay?
We got about 500 pages of documents that the state apparently had, and we just got, so 15 minutes is a very...
Judge, I haven't had a chance to interview him. I don't know what the cure is, other than to ask Your Honor for more time so that I can spend some time talking with him about whatever he's going to talk about and potentially try to review at least a couple of these articles before. Where is he?
He's in our office, Judge. I've already indicated that the court was going to give them time to speak with him. He said that's fine. The documents they're talking about are the ones they asked us for, the articles that he references in his report. I don't anticipate he's going to testify and state any of those article names, but they asked for them, so we provided them.
All right. I'll check with you in a little while, okay?
Right. Thank you, Judge.
We'll be in recess 15, 20 minutes. try. All right, ask the jury to join us, please. Excuse me. Oh, I'm sorry. Hang on. Yes, sir. Of course.
Ms. Merchant and I just was able to talk with Mr. Posey for about 15 to 20 minutes. Ms. Hart joined us for the interview, and it is clear, Judge, from his interview in 15 minutes that what he is going to testify to is exactly what you have said he cannot testify to, and that the only thing he's here to do is to do a statement analysis of Ryan's statement that he said his charge was to corroborate that Ryan's statement was true. That's what he's here to talk about. So he's going to get on the stand and talk about that. And he said one of his charges was to determine whether this is a true confession. We asked him questions about the substance of his testimony being focused on Ryan rather than the interview technique and being focused on Mr. Shadell, which is what I thought he was going to testify to, he kept anchoring back to Ryan's statements. And so we think he's going to go line by line through this statement and say, this is corroboration that he was telling the truth, which is a jury issue.
Right. How did he get that impression, Ms. Hart?
Because of the questions he asked him, Judge. If somebody asked him a direct question, if he has an opinion as to whether or not this is a false confession, he's going to answer that question honestly. And what he said was that originally he was asked to assess whether or not this was a true or false confession. That was back in the days before Your Honor had ruled that they could not go into false confession theory. My questions to him are going to be exactly what I went through this morning with the court. In fact, I was reading from my notes about what I'm going to ask. Yes, this is Inspector Posey. If he's asked, is this a true or false statement, he would have to answer that honestly, which is what happened in that room. I'm not going to ask him that, Judge. And the other question they ask is the purpose of your testimony to provide, and I'm trying to remember the words they use, but essentially at the end of the testimony, do you want the jury to believe that this was a true statement?
You have a clear understanding what my ruling is?
I have a clear understanding, and I've even retexted it to him this morning, so he can't even, I've even texted him again to say you cannot say even if it's consistent with a true or a false statement. And I'm not going to tell you that this morning, Inspector Posey.
Right. And just one last thing, Judge. He did tell us this is going to be the first time he's ever been tendered in this field.
Which they can certainly put iron him on.
In terms of the way it comes out with the question.
Sure, yeah. Okay. That's what it's board iron.
Is the court willing to entertain a proffer at least, but to this questioning on direct to make sure that we don't run afoul here, and go into areas that obviously will need to be addressed on cross and open Pandora's box on this issue?
Judge, I literally this morning went through my notes of the questions to ask him.
Yeah, let's, now we're just going to take his testimony. Please object if you believe anything's outside the scope of what's ordered. Thank you.
And Judge, just for purposes of the record, we would formally request a continuance of a day to interview him properly, to review the literature that he's attached to his report that he says he made part of his findings that we haven't had a chance to review. So I know Your Honor is not inclined to do that at this point, but I just wanted to make sure we asked for it.
All right. That's overruled. Thank you. That's adjourned again. All right, thank you for your patience, ladies and gentlemen. We're ready to proceed. Call your next witness, please.
Your Honor, it's time to state Defender State's Exhibit 293, which is a certified copy of Bo Duke's conviction out of Wilcox County in case number 2017 CRW 38 for making false statements, hindering apprehension of a criminal, and concealing the death of another. We would tender that certified copy tonight.
Any objection?
May I just wait to respond until after we deal with the next witness?
Well,
We might have an objection, I just needed some time to think about that before, if that's possible.
all right, call your next witness, and then we'll take that up.
Your Honor, state what's called Mitchell Posey to the stand.
Good morning, sir. Good morning, sir. You'll come down there. Before you're seated, please give your attention to Ms. Hart there. She'll administer the oath.
Do you swear affirm testimony before this jury, the truth, whole truth, and nothing but the truth?
I do.
Have a seat for me, please, sir. And try not to hit anything with the paper. And can I get you to introduce yourself to my jurors, please?
My name is Mitchell Posey, and I am an inspector with the Georgia Bureau of Investigation.
Now, can you tell us what the role of an inspector is at the GBI?
Inspector is a command staff level position within the investigative division. And what in essence that means is my job is to help our director, our division director with hiring, policies, operations, but it's also to supervise and support other work units. I oversee 8 other work units to include field offices, drug offices, specialized offices. So I work in support of them. And the easiest way for me to tell you what I do is I try to get them what they need to do their jobs, because they are the boots on the ground doing the everyday job. I'm not doing that any longer, and my job is to help facilitate and make their job easier.
Okay. How many inspectors are employed at the Georgia Bureau of Investigation?
There's 4 of us.
How long have you worked for the GBI?
25 years.
And have you always been an inspector?
No, thank you, ma'am. No, that was an appointment made by the director in 2019.
Tell us, what was your job assignment with the GBI prior to the appointment to inspector in 2019?
I was a special agent in charge of the Appalachian Regional Drug Enforcement Office in Cleveland, Georgia, which meant I was a work unit supervisor over a multi-jurisdictional drug task force. They included GBI agents, GSP, National Guard, and many local sheriff's officers and police officers from North Georgia. So I supervised, if we were fully staffed, that's always a big if we were fully staffed, 25 people to work narcotics in North Georgia.
Okay. Other than inspector and special agent in charge of that drug task force, what other job assignments or roles have you had with the GBI over the years?
So one step down, I've also served as an assistant special agent in charge of the regional field office in Cleveland and the same Appalachian Regional Drug Enforcement Office. Now let me make a distinction here for you. It used to just be a small drug task force, which was only me and 7 other people, and I was an ASAC there, and then as an ASAC I supervised the drug office. We eventually grew into the animal that I just spoke of, and then I became a special agent in charge of it. Prior to that, I was a special agent, and I was a special agent in the Cleveland field office. I was a special agent in the Americas field office. I'm originally from Cordele, so I started my field operations in Americas, which means what I just spoke of earlier. I was the boots on the ground guy, grabbing my notebook, grabbing my pen, grabbing my recorder, and going and talking to people in investigating crimes.
How long total were you employed in the role of special agent, boots on the ground, as you called it?
From 97 to 2008, so almost 10 years. No? Yes.
And what about, before being a special agent in the Americas office, again, did you have any other jobs with the GBI?
Prior to being a special agent, I was a narcotic agent, which we used to have a program, we don't have it anymore, where you were a narcotic agent in which I was an undercover agent. All I did was undercover work. I didn't do anything else but undercover drug buys. And I did that for a year. Prior to that, my very first job in the GBI is I was a medical examiner investigator. And what that means I did is I was the go-between between the pathologist, the doctor, and the investigator. It just meant that For a year, I was in the autopsy room watching autopsies. And then I would report back what the doctor said to the investigators so that they had accurate information.
Specifically in your time as a special agent, I'm going to talk about that right now. How many years did you say you were a special agent? Sorry.
So from 2008 to 97 is 11 years.
Okay. Did you have an occasion to conduct investigations with witnesses and potential suspects in criminal cases?
Every one of them.
Okay. Any way to estimate for this jury how many interviews you've done over the years with potential suspects in cases?
Just with suspects?
Potential suspects, yes. Or suspects, whatever word you want to use.
Well, again, that's, I would say that's every single one of the cases I ever worked. Because even if an accusation was made against someone, we still interviewed them. Now, we might have cleared them. I definitely want you to understand this. Within my GBI career, because I've thought about this many times before, is I have cleared way more people of accusations than I have actually put handcuffs on. So it's going to be more than the actual number of cases that I've worked.
So can you give me an estimate? More than 20?
Not only cases I work, but cases that I helped on, because the GBI is a big team approach. We rarely do anything alone. I'm going to say between 250 and 500.
Sorry, give me that number again. I couldn't hear.
Between 250 and 500.
250 and 500. Okay. And have you ever taken any training specific to interviews and interrogations?
Yes, I have.
Can you tell the jury what trainings you've taken specific to interviews and interrogations?
So I've had 12 different classes throughout my career in interviews and interrogations.
Tell us about the first one that you can recall.
The very first one I was a part of was our Basic Agent Academy. So we had a 40-hour class that gave us the basic of interview and interrogation. From there, I went to the Georgia Public Safety Training Center's basic interview and interrogation class. Then I attended a READ class that was specific to child abuse. Then I attended a statement content analysis class that was taught by laboratory scientific interrogators. Then I was back to the Georgia Public Safety Training Center's advanced interview and interrogation class. Then I took another GBI class, interview and interrogation class, because now we're getting on into my career, so I took, it wasn't the same class, it was an advanced class, but there was a lot of the same information to make sure that I added to my toolbox, put more tools in my toolbox, or that I remembered that I still had some tools in my toolbox that I might have forgotten. Then I took another READ class, which was just their general specific READ class along with their advanced READ class. Then I took a class from my original instructor, who was retired inspector, meaning he held my position, and he was my original GBI interview interrogation instructor. Once he retired with us, he became a chief deputy in North Georgia and taught at Columbus State Command College, and he continued to teach interview interrogation. I took another class from him, again, just adding to my toolbox or remembering tools that I'd forgotten that I actually had in the toolbox and getting it back out. Then I took it's called a tactical interviewing class, but it really was just a statement content analysis class again, like I'd taken before. Then I took a class at the Federal Law Enforcement Training Center, which was, and this was recently, this was earlier this year, of advanced interview and interrogation class. And then finally, I've taken a online class with our profilers in training, of false statements, a false statement class.
Okay. So I want to focus on, first of all, you mentioned taking these courses related to READ. I don't want to go into details very much about what that is now or what that contains, but can you explain to them why we call it READ?
John Reed is the owner of the company and the creator of the technique.
Okay. And is that we'll come back to that, but you've taken how many classes in READ technique?
2 basics, 1 advanced.
Have you ever had an occasion to train others as it related to interviews and interrogations?
Yes, for 5 years, I was the lead interview and interrogation instructor for the GBI. And I say lead, and that just means that I created a team of what I felt like were really good interview and interrogators within our agency that could properly educate and teach other people how to do them.
Okay. As lead, did you also participate in the training as well?
Oh, yes, yes.
Prior to becoming the lead, did you have an occasion to participate in training of other agents yourself?
Outside of interviews?
Yeah, no, anything?
Yes.
Okay. And as part of the training that you did or that you were over, was that just for GBI agents?
No, we also were the lead instructors for the Georgia State Patrol and the Georgia Public Safety Training Center in Forsyth. My team did. Now, we had agents that did other regional academies, but my team did not take on that task because it was just too much for us. And I've also participated in 2 contract trips to the Republic of Georgia, which is the other side of Russia, to teach 2 classes to Republic of Georgia National Police, interviews and interrogation.
And when did you take those 2 trips to South Georgia, not this South Georgia, but 2 trips to teach that? If I got it wrong, you correct me. When did you take those 2 trips?
2014 and 2016.
And it is Republic of South Georgia, right?
No,
No, what is it?
it's Republic of Georgia.
Republic of Georgia, okay. And you said that particular training was to who in the Republic of Georgia?
The National Police, Republic of Georgia National Police.
About how many people were you assisting in training during that time period?
Everybody, or are you still talking about Republic of Georgia?
Republic of Georgia.
Oh, let me correct myself. There were actually police and prosecutors in that class. I just remember their prosecutors were also in the class. First class, there was probably 30. Second class was a little smaller, it was probably 20, so 50 total.
Just talk about a few things you've done even outside of interviews and interrogations. Are you just a post-certified instructor generally for law enforcement officers?
I have been since 2002.
Have you ever co-authored any books or training manuals during your time as a law enforcement officer?
The GBI's Death Investigation Manual. I co-authored it.
The training materials that you used when you were over the 5 years that you were over the interviews and interrogations for GBI, did you have a hand in what training materials were used?
I did.
And then outside of the actual formal training that you've done of other agents and other officers, have you had a chance to review or assess interviews done by other persons or other law enforcement officers?
Yes, and this goes back to the beginning of time and beginning of my time with the GBI, which was 1996. My DNA and the way I'm wired is I always want to learn and grow and get better. So, and I believe 100% in the team approach, and I love working in teams. I don't like working by myself because I feel like within that team approach, they'll always be able to give me good feedback to help me get better. My point in saying that is I love to go to do interviews and interrogations with other agents, especially agents that I'd seen successful and that were good at interviews and interrogations, or I'd ask them to come do an interview for me so that I could see it, I could see their techniques, I could see their tactics, I could see how they talked to people, how they treated people, what worked, and then also things that I didn't like that I would say, okay, I don't want to do it that particular way. That's not my style. I've done that from the very beginning. Definitely when I became a field training agent in 2002, I was directly responsible for brand new agents and teaching them how to do interviews and interrogations. First month of the field training program is they watch us do everything. The second month is it's half and half, in which I'm doing half the interviews, but then I'm watching them do interviews and I'm giving them an assessment of what's working and what's not working. In the third month, it's almost like I take the month off because all I do is watch them work and give them assessments. Catapult that until when I became a supervisor, because of what I told you about my DNA, naturally I I feel like that the agents that work for me work with me should have the same mindset, so I would review their interviews and interrogation. I'd either be there, watch it on video. I may be in the room. I just may be in the room in the back corner, or watching it again from a remote video, or I may listen to the audio or video depending on how they documented the interview later after I read the summary, and that was always just to give them an assessment of this is what's working, this is areas we need to improve on, and also give them some encouragement on these things are doing really well, people are really responding to you well, or give them some guidance that you've got to get better with this. We got to get you in some training because we can't keep making these same mistakes.
Any idea how many times you've had an occasion to, to review or analyze interviews done by other agents?
Definitely over 250.
Okay. I want to focus a little bit more on, you indicated that you took advanced interviews and interrogation earlier this year at the Federal Law Enforcement Center, is that right?
Law Enforcement Training Center. But yes,
and
ma'am.
Where is that located for those who may not be familiar?
Brunswick, Georgia.
That particular class, now to clarify, were you teaching it or were you learning?
No, I was a student.
And who taught that course?
The instructors at FLETC. FLETC is the acronym for Federal Law Enforcement Training Center. Call it FLETC.
That particular course, was it based on the work that has been done by anyone specifically?
So it was a collaboration between Dr. Brandon in her book, Science-Based Interviewing, to create that class.
Okay. And her book, Science-Based Interviewing, in addition to taking this course, are you familiar with that book?
I am now because I've read it.
Okay. I forgot the name you told us. I apologize. What was her name again?
Dr. Brandon.
Dr. Brandon?
Brandon.
And can you spell that for our court reporters?
Brandon. Susan Brandon.
And Dr. Brandon, do you know what kind of doctor she is? What is her specialty?
Psychology.
Now, Dr. Brandon, do you have any knowledge of what experience she has in the field of interviews and interrogations above being a psychologist?
So she was the head of the research arm for HIG, which is an acronym for high value detainees, terrorists. So when President Obama did away with waterboarding, they had to come up with a way to continue to interview terrorists and get good information from terrorists, but of course do it in a humane way. So she was the research arm of that interacted and worked directly with people like me that would be doing the actual interview. And so her book and her assessment came from this work.
Both the training and the book, which you're now familiar with, does it focus on, or does it talk about the psychology behind interviews and interrogations?
Yes.
Is that something, the psychology behind the interviews and interrogations, is that something that you utilize in either conducting an interview and interrogation yourself or in helping to train others?
Yes.
Okay. Now, I've been using this phrase, interviews and interrogations, so let me ask you, is an interview different from an interrogation?
Absolutely.
Can you tell the jury the difference between the two?
Judge, this has been attended. I'd like an opportunity to voir dire him first.
You haven't tendered him yet?
I haven't, because I don't believe that this question requires him to be tendered. I actually believe it goes towards the foundation to tender him as an expert, but I do believe I've laid a proper foundation at this point. Defense counsel wants to voir dire him on his expertise. I'm sure that the court will be satisfied.
All right. You can proceed, Mr. Merchant.
Morning, sir.
As I understand it, you have not been tendered as an expert in the field of interviews and interrogations, is that correct?
Yes, sir, that's correct.
So this will be the first time you testify as an expert in that field?
Yes, sir, that's Steve.
The last time you received any instruction on the read technique was 2013?
Yes, sir, that's correct.
And I know you've reviewed and assessed, you said 250 interviews or so. Is that since 1996?
Yes, sir.
Okay. You've never published anything in the field of interviews and interrogations, correct?
No, sir, I've not published.
And you've never published or prepared any training materials that were used to train other GBI folks?
No, sir, not published.
Okay. And, or to train anybody else, whether they're GBI or not, correct?
Meaning, ask your question the way I can understand it. I don't understand that question.
Have you ever prepared any training materials in the field of interviews and interrogations for anyone?
Now, I have prepared training material. That's why I'm trying to understand your question specifically, because when I led these programs, I prepared the material, compiled the material, found material that I liked, and maybe this answers your question. Is something, I don't reinvent the wheel. There's something there that I like from another class, another instructor, then I'll pull that slide and that material. And when I did this, I pulled it from 3 different instructors, which or 3 different classes, which I liked and I knew to be successful. And I compiled that and created it. To your question is, did I specifically write it? No, not every single slides are there. So no, sir, not specifically write it.
Right, and that's what I was getting
Okay.
to. Maybe the word I should use is author. Have you personally authored any training materials?
Not for training materials, no, sir.
And the teaching time that you have, it's a total of about 140 hours. Does that sound about right, over 5 years?
Meaning each individual class?
As a total, for the time between 2014 and 2019, that was the 5 years you acted as supervisor, the training, right?
Right.
So during that 5-year period, it looks to me like you had about 140 hours total of teaching time.
Well, if there's an agent class every year, there's 40. That's 40 hours times 5. That's 200 there.
Okay, so and that's the total of your hours. Though you have the 40 hours, 40 hours, 40 hours. Those are team taught, right?
Yeah.
So you didn't actually provide personal instruction for all of those hours, correct?
No, I was not the lead, but I was always in the room. And the great thing about being the lead, when you're instructing, not only do you have to think about what you're saying, but you also have to think about what's coming next as you instruct. The great thing about me being in the room is I had to make sure I facilitated the same message from one instructor to the other. So I was always adding to the instructions each and every hour with every instructor.
Let me ask this question. Of your teaching time, you only have 16 hours total for these courses each year, correct? Of your own personal teaching time, or you're not part of the team?
So 40 hours for a GBI class, 8 hours for a trooper class, and 8 hours for a mandate class. So let's just, to keep things simple, let's just say 50 hours a year times 5. So if we really want to be accurate, we just need to say 50 hours a year times 5, which if my math is right, comes up to 250. Regardless if we want to split hairs about team or individual, I'm there and I'm participating.
Yeah, so I'm not trying to quarrel with you about the exact numbers. I'm just trying to figure out when you were providing instruction solely on your own. How many hours?
250 hours.
Excuse me?
250 hours.
Okay, on your own, over the course of 5 years?
Yes, sir.
That's all I have. Thank you.
All right, Ms. Hart?
All right, I guess based on the objection, I'll go ahead and move to tender him as an expert in the field of interviews and interrogations.
I would object, Judge.
All right. And the basis of your objection is not?
It's not qualified.
All right. Ladies and gentlemen, of course, respect those adheres to the United States as an expert in this field of interviews and interrogation. I'm going to admit him as an expert in that field over the defendant's objection. As I've cautioned you before, the testimony of an expert witness you should treat just like the testimony of any other witness and give it whatever weight and credibility you believe it's entitled to. Thank you. Ms. Hart, you can proceed.
So let's go back to the question I had asked, which is, can you tell the jury the difference between an interview and an interrogation?
So keep this thing real simple, because I'm a simple kind of guy. An interview is nothing but gathering information. It's a conversation with someone just to learn information. Just that simple. That's an interview. Yes, in an interview, we're taking notes. We're not being judgmental. We're not being accusatory. We're not being difficult. We just want to learn. In an interrogation, we've now moved into an area in which we feel like the person probably has committed the crime, more than probably has committed the crime. Our questions are a little bit more direct. We will confront the person and let them know. Confront means I'm going to tell you that I believe you're responsible for this. That's what a confrontation means. I'm going to let you know just so you're not wondering, does he think I did it or doesn't he think I did it? I'm going to tell you, I'm going to be direct and tell you right up front that I believe, and our statement is investigation clearly shows you're responsible for in whatever crime that we're there to talk to. We're not going to take notes. And we're probably going to do, in the interview, they're going to do most of the talking. In the interrogation, we're going to do most of the talking. So two totally separate things.
Okay. The training that the GBI provides to its agents in Georgia, is it based on this idea of separating an interview and an interrogation?
Yes.
And want to move then to talk briefly about what we've referred to as the Reed technique. The Reed technique, does it base its idea on these being two separate parts of interviews and interrogations are separate?
Absolutely.
Okay. In Reed's training, is there any moment or is there any action which is suggested that clearly separates the interview from the interrogation?
Yes. At the end of the interview, Reed asks you to step out of the room for a couple of different reasons. One, if your partner's in the room with you, so y'all can have a conversation about the interview. And so you guys can make a decision, and if they're not in the interview, then if they're watching on the video, so you guys can make a decision. Is there something else investigative-wise that we just learned that we now need to stop what we're doing and go do the investigative act, i.e. another interview, to corroborate or confirm or disprove what was just said, that we need to do that, one. Two, do we feel like this person has committed this crime and now graduate into the interrogation and continue on? Three, do we feel like this person has committed this crime, but we don't feel like we're properly prepared to go to the interrogation? Then you got to make a decision of, if they leave, will you be able to bring them back? So there's a conversation of, have we done everything that needs to be done? And then there's a decision that has to be made. Are we ready to move to the interrogation stage? That has to be done. And then you come back into the room and immediately starts with the direct confrontation, which I've already spoke of.
Okay. If someone is familiar with Reed technique, truly familiar with Reed technique, would there be any way for them to confuse the fact that interviews and interrogations are two different things?
No.
And this leaving the room that you're talking about, is that something that, again, if you're truly familiar with the Reed technique, that you would not know about? Is that something you would not know about?
I sustain that.
Okay. Tell us or can you tell the jury, please, how important this idea of leaving the room is to Reed, or how unimportant it is?
Well, because of everything that has to be decided, it's very important. Again, especially if you're working in pairs with a partner, because, again, this is why I love team. You're going to miss stuff. There's going to be things that happen in an interview that you're going to miss. There's going to be things that need to be asked that you don't think about in the moment of the interview. So having that moment to step out is critical. It's critical to, again, have that teamwork of let's get on the same page, make sure we both agree, and step out and have that. So it's critical.
Okay. Let's transition now to talk about this specific case. Before I ask this question, did you do actually any investigative actions in this case as an agent?
I did not.
Other than you're testifying here today, did you have any involvement with the investigation into Tara Grinstead's missing person?
I did not.
Okay. In being asked to come and testify today, however, did you review any documentation?
I have.
Can you tell the jury what you reviewed specific to this case to prepare for your testimony today?
I reviewed the interviews, all interviews with Ryan Duke, and then I also interviewed any investigative acts which I felt like corroborated information from that interview.
Okay, so let's clarify. When you're saying interviews, have you watched video footage of Ryan Duke?
I have.
Have you listened to audios of Ryan Duke?
I have.
In your, did some of the videos you watched overlap with the audios you had?
They did.
In your assessment of this, and in preparing for today's testimony, have you separated out one interview from the other?
Yes, there's a part 1 and a part 2.
Okay, so just so when we're talking about part 1, part 2, can you tell the jury what you mean by part 1?
Well, they're broken up into 2 different files, and in the part 1 is from the beginning all the way through basically right before they leave the police department to go to the orchard. Part 2 then starts from that moment and is the journey to the orchard, what happens at the orchard, and then the journey to the detention facility.
Do you recall if you, during your listening to and watching these interviews, did Agent Shadell fill out any administrative paperwork while he was speaking with Ryan during either of these interviews?
Administrative paperwork, he filled out an arrest record.
Okay. And is that something, are you familiar with what we refer to as an arrest record?
I am.
Do you recall which portion or which interview contained the arrest record?
Part 1.
Part 1 is the arrest record. Okay. So I just want to be clear when we're talking about it. Now, you also talked about, in addition to listening and watching those interviews, have you had an occasion to review a transcript?
I have.
And who actually requested that transcript be made?
I did.
Why did you request that transcript be made?
Based on my experience, that again, you can miss things when you're listening to the audio, so it's best to have the transcript where it's line by line by line, whereas you're listening to it, you're also reading, and you're just going to pick up on more information when you're doing both simultaneously.
Okay. And then tell us about some of the evidence that you reviewed specifically in this case, please.
Evidence from?
Physical, sorry. You said other than the transcript and the actual interviews and themselves with Mr. Duke, what else did you look at in this case file?
So I looked at SAC Rossler's crime scene examination. And are you asking me to go through that, or just are you asking me?
No, just what they were, not the specifics of it.
I looked at Agent Crosby's examination at the orchard, along with Dr. Gooding's report. I reviewed SAC Baudry's summaries about the phones. SAC Baudry, I believe, also wrote a secondary crime scene summary that was titled Caller ID. I reviewed that along with Agent Lewandowski, former Agent Lewandowski, and Agent Weathersby's secondary crime scene summary.
Okay. Have you looked at any photographs from the case file?
Oh yeah. So when I looked at all the photographs from Tara's house. I did not look at all the photographs from the orchard, but I did look at some of them.
Okay. Why didn't you look at all the photographs from the orchard?
Because there was a lot of them.
Okay. Did you look, I guess my question is, did you feel that you had access to all the information you needed in this case?
I did.
So let's actually talk about your assessment of the interview. If you can, talk to the jury about how this first interview begins and why that is important to you.
The way the interview begins is extremely critical. Agent Shadell makes the statement / question to Ryan that you didn't ask me yesterday why we wanted to interview you. Right away, Ryan responds that essentially that it's about Ms. Grinstead because he's involved. Wonderful next follow-up question, which is a great open-ended question of, tell me what happened. Ryan says, in essence, gives a statement that he used to break into people's houses to steal money. He was a drug addict. He'd been drinking. He was high. Can't clearly remember everything, but I was stealing from her purse, and she snuck up on me, and I hit her. I didn't mean to. Purely reactionary. But then I ran. I didn't know what else to do. So within the first 1 minute and 30 seconds of their contact together of this interview, with no influence from Agent Shadell, no interview tactics or techniques whatsoever, you have an admission of guilt from Ryan about the murder of Tara Grinstead. And that's the foundation. That first minute and 30 is the foundation from which I built my assessment. I'm an analogy guy. So foundation, I'm speaking on foundation of a house. So it's really good and it's strong, but nobody lives on a foundation. We now got to build a house on top of the foundation, which means we got to have more. So from the interview world of building a house is I've got to now look for details, because I've got a great foundation. I've now got to look for details about the admission, and then I've got to find information that will corroborate those details.
Okay. And I want to make sure, just because I want to make sure I heard you correctly, at the beginning of that, did I understand you, I want to make sure I didn't mishear the word, did I understand you say that first minute and 30 seconds is critical? Is
Yes.
that the word you used? Okay, I just wanted to make sure. So you talk about needing to then build on this foundation. What do you actually do in assessing, or what did you actually do in assessing this interview to then build on that foundation?
So again, I'm listening and I'm going through the transcript and I'm looking for the details that I just spoke about. Because again, we got a good general foundation, but now I've got to find the details. And then once I find the details, then I've got to go to other investigative acts. A good example is a crime scene summary, and find if I can match that, if it matches each other, if it's the same, or if it conflicts with each other. Because if it conflicts with each other, then I need to circle that and say, well, okay, we might have an issue here.
Okay. In your review of the other documents in this case, did you determine if there was any evidence that would have been corroboration of things that were said during the interview?
You can only testify on information that's not present.
Judge, I'm specifically asking him about evidence that he reviewed, not anything that he has heard about, but evidence that he reviewed, he's seen pictures of, that have also all been tendered into evidence.
He hasn't identified exactly what he's referring to.
I think in his role as being tendered and accepted as an expert, he can consider that informing his conclusions. I'm going to overrule that objection.
Thank you. Do you need me to repeat the question?
Please.
Based on your review of the actual evidence in this case, did you determine if there were any items of corroboration related to the confession that you saw?
Yes. Yes. Yes.
Okay. So let's talk about some of those.
Okay. So as I'm reviewing, the first thing that catches my attention, and I need to define it for you, and that's guilty knowledge information. And what guilty knowledge information is information that's only known to the investigative team and the person responsible for the crime. That's why we call it guilty knowledge information. So it's information that the investigative team is held back, not released to anybody. They held it back, which shows a lot. It showed a lot of wisdom from the early agents that worked this case, that I'm not going to release this information. And that came in the form of the payphone. So Ryan discusses, after he leaves the residence, before he comes back to get her, that he calls her. He calls the house to see if she's okay, to see if she'll answer, because he wants to know if she's okay. From the G&G, he even mentions that the payphone is in front of the G&G, and he mentions, and this is so important, he calls 411 and gets connected directly to the house. Very, very, very important,
Why was that very important?
because it was not known. I work for this agency and I didn't even know it.
And to be clear, when you say you work for this agency, were you in a position of command with the agency and didn't know it?
No, not then, but
Well, let me go back. I'm using the word command, and I know you're a very specific person. Were you a supervisor in this agency and did not know about it
not back then, no.
before you were asked to review this information?
Oh, I'm sorry. I'm sorry. I thought you meant in the beginning.
No,
Yes.
no.
Yes.
Prior to you being asked to review this case, did you have any knowledge of that payphone call?
No.
And so, is there any other corroboration above and beyond the phone call that we see?
So the next really good piece of information, and we call it independent corroboration. Independent meaning that the investigative team didn't know this information until the interview. Ryan taught Agent Shadell. Ryan is the one that gave us this information. The question was, how did you identify Tara? The answer is pictures on the wall. Okay, so stop what I'm doing. Let me go to photographs. Let me go to summaries, and let me go to photographs, because what should I see? I should see pictures on the wall. If I don't see pictures on the wall, then I might have a problem. There was her pictures on the wall. So there was a picture on the wall in the computer room, and there was a picture on the wall, even though it was on the shelf, and I'm not going to wordsmith him to death, in her bedroom, which confirms his statement. It matches.
Okay. Now, I want to talk about what you're saying about the pictures on the wall. Have you reviewed, to your knowledge, each and every crime scene picture from Tara Grinstead's home from 2005?
Yes.
Okay. Now, I'm going to show you, first of all, what's been introduced and admitted as State's Exhibit 79.
If you'll help us, please, Ms. Watkins.
Yeah, we're
Thank
going
you.
to turn that screen up in front of you. Thank you, ma'am. Are you able to see that exhibit in front of you, sir?
It's pretty washed out,
Okay.
at least the...
So let me see if I can change it. If not, I'll bring it to you. Nope, it's not going to get any better, is it? Okay, I'm just going to bring it, let you see it, and then we'll put it back over here so you can describe what you're saying. Take a look at that for me, please, sir.
Again, they're washed out, and I know there's picture frames there, but I can't see them.
And that's what I want to talk about. So, looking at States 79, now I've messed it up completely. You just made a statement that you know there's picture frames there. My question to you is not what's in the picture frames. My question to you is, when you're talking about pictures on the wall, are you talking about pictures of this nature that would be on another piece of furniture?
I'm not. When I'm assessing this, I am taking him for his word. Specific. Pictures on the wall. That's specific. So I'm looking for pictures on the wall.
Okay. So then you mentioned that there was one in what you referred to, did I understand you to say the computer room?
Correct.
I'm going to show you what's been introduced as State's Exhibit 91, understanding it's a little washed out, but can you see State's Exhibit 91?
I can.
Do you recognize State's 91?
I do.
How do you recognize State's 91?
That same one right here.
Okay.
In my notebook.
And
From the crime scene. This is picture from the crime scene summary.
okay. And this particular picture, are you familiar with where it was located in the residence?
In what was called the computer room / spare bedroom, I believe they call it.
Okay. And why do you have this particular picture in your report?
Because anything that I talked about, that I'm talking about confirming and having, I wanted to have right here with me.
So do we see the picture on the wall that, I know these are silly questions, but I'm going to ask them anyway. Do we see the picture on the wall that you're talking about here?
I do.
Okay. And again, is this consistent with what you were talking to the jury about with the corroboration?
Correct.
Okay. Now, you also talked about a picture in another room. Do you recall what that room was?
It was her bedroom.
And do you know if the picture from her bedroom was actually taken into evidence in this case?
It was.
And who took that into evidence?
SEC Baudry.
Now, that particular picture, where was it located in her bedroom?
It was on the wall on a shelf.
And I'm going to show you first, and then I'll put it underneath. State's Exhibit 21, I ask you to take a look at that for me. Can you see the shelf that you're talking about in this picture? I know it's probably not the angle you have, but can you see the shelf you're talking about? No. Okay. Do you have a copy of the picture of that picture that you've been talking about in your mail?
No, I never received it.
Okay. So you're going based on now your understanding from the crime scene.
Correct.
So that particular picture that was taken, other than that and the picture that we're looking at in State's Exhibit 91, in your review of the pictures from the case file as well as the crime scene summaries, were there any other pictures actually hanging on the wall of Tara Grinstead? As in pictures of herself?
Hanging on the wall?
Hanging on the wall.
Not that I saw.
Okay. So again, talk to us about why that's important to you based on Ryan's statement.
Because it's information the investigative team learned during the interview. So it wasn't known beforehand. They learned it, and then you can take that information and you can confirm it to ensure that it matches what he says, and it matches.
And to clarify, when you say it wasn't known, are you saying we didn't know there were pictures on the wall?
The investigative team did not know how he knew this was Tara Grinstead.
Okay.
Obviously, that's not known.
Okay. Any other physical evidence in this case that corroborated what you heard from the defendant?
Yes. So let's stay at the residence, and let's start with again the crime scene. Is Ryan mentions how he gets into the house, pops a lock. Agent Shadell is the first one to mention credit card, and of course Ryan does not dispute that. The point is it's an entry by unforced means, meaning not kicked in the door. We didn't break a glass. It's being able to gain entry into the door without tearing it up. You look at the crime scene photographs, and that's what you have. You have a clear picture of the latch of the door, or excuse me, the door frame, and it's not broken, which again it matches his statement.
Any other physical evidence at the house?
Yes.
Okay, tell us about that, please.
Ryan talked about when he came back to get Tara, take her to the disposal site, that he brought latex gloves, translucent gloves. So you look at that from the crime scene, and lo and behold, there's a translucent latex glove in the yard that has his palm impression in the glove, has his DNA in the glove, and has Tara's DNA in the glove. The next part is Ryan, from this crime, from the crime scene, is Brian said he did not see any blood at the crime scene. You have two different crime scene examinations specific to that indicated there was no blood at the crime scene, minus excluding blood that was found underneath of Tara's comforter that was on her bed. And when I say underneath, meaning if you look at the photographs, the bedspread is down, but if you pull it back, then you see blood on the other side. Very important information for me. Well, I'll stop.
Okay. And to be clear, when you say that the blood is underneath, based on your review of those crime scene photos, could the blood on the comforter be seen without first moving the comforter?
I didn't see it.
Moving on from the house, is there any other, again, evidence in this case that stood out to you as corroboration? Thank you, ma'am.
Ryan talked about taking Tara's body to a field in Fitzgerald. And then he gets in the car with the agents and helps them go to this field. He talked about cremating her body, burning her body, and the agents in this area where Ryan helped them get eventually found the right spot that had, according to Dr. Gooding, human bones that had been burned. Again, all this matches, this crime scene stuff, crime scene analysis matches his statement. He also talked about taking household trash to this disposal site where the body was burned. Lo and behold, even though it's this many years later, as they're sifting through this, they find household trash. Again, it matches what he says.
Okay. Have I missed any of the corroborating details? Have we not talked about any that are sticking out to you that I've missed?
No, ma'am.
Okay. So I want to stop here and talk about then what we've mentioned earlier about the psychology of interviews. In your training and experience, and then also research about the psychology behind interviews and interrogations, separate and apart from law enforcement looking at corroboration, do the experts also look for corroboration, that being the psychological experts, in their research?
I don't understand your question.
I knew you were going to tell me that. Okay. In the psychological research that you've done and based on your training experience, is there a connection between the psychology of research and evidence and this idea of finding outside corroboration or physical evidence?
Yes.
Okay. Can you tell the jury what that is, please?
So in doing my research, and I want you to understand that when I did research, yes, for 25 years I've been trained by the GBI, law enforcement, in law enforcement ways. But in the course of this case, and this case pushed my horizons. This case made me check my blind spots to the old "you don't know what you don't know" adage of look at your blind spots and see what you're not seeing. And it made me start doing a better job of reviewing papers, research projects from psychologists about any and all things related to law enforcement professions, techniques and tactics, generally negative, which is why it's on the forefront, because it's generally a negative thing. And what I've came to learn from that was important to my assessment, I've already talked about one of them, is that what's important is, in people generally talking, is evidence. Evidence is very important. Another thing that's extremely, extremely important is the interviewer building a relationship, building rapport with the interviewee, meaning earning their trust, being nice to them, being a nice person, so they want to talk to you. Very, very important. Another one is understanding and looking at internal pressure. Internal pressure is nothing more than a guilty conscience. And don't overcomplicate that. Mom and Dad taught all of us this. Exactly what a guilty conscience is, and if you've done something wrong, then you should be guilty about it. Mom and Dad taught us that. I didn't have to be taught that by law enforcement professions or psychologies, but it's the same thing we've all had and experienced throughout our lives.
Okay. You talked about internal pressure in relationship to an interview. Is there also external pressure that we look at?
There's also external pressure, which comes in the form of the pressure police put on an interviewee, on someone we're talking to to talk to us, to be, this is my definition, if that's occurring, to tell the full story, to be truthful about the full story. We want, obviously from the very first time that investigator gets the phone call that I've got a problem here and I need you to come help, our goal is to learn and understand the truth. That's the goal. And that's the goal all the way through the very end. And it never changes. That never changes regardless of what's going on in the middle. From beginning to end, the goal is always, let me understand what happened here. Let me understand what truly happened here.
And before we go any further, I need to ask you this. In this particular interview, do we ever get to an interrogation? Did Jason Shadell ever get to the interrogation portion?
No.
Okay. So when we're talking about this case, do we ever really need to talk about interrogation tactics?
No.
As we're talking to this case, were there any external pressures created by Jason Shadell that we're going to look at? Were there any at all, I guess would be a better question.
In terms of threats or putting pressure on him, no. I did not see him.
Okay. So I want to talk a little bit about some specific techniques that can be used in interviews and interrogations. And I think these may be somewhat specific to Reed, but you'll tell us if I'm wrong. Have you ever heard of the phrase minimization?
I have.
Can you tell the jury, when we're talking about interviews or interrogations, what we mean by minimization?
Make an excuse. Real simple. And it's not specific to the law enforcement profession. It's not specific to Reed. Everybody makes excuses for things that they've done that they don't really want to talk about the real reason behind it. All the way from the reason you didn't do your homework to something else that you've done wrong. Everybody minimizes the true account of what you know is in here. Doesn't always come out of here. Everybody does it.
Okay. Now, in this particular interview, does minimization occur?
It does.
Who minimizes in this interview?
Ryan is the first to minimize in this interview, but Agent Shadell also minimizes in this interview.
Okay. Is minimization on the part of the law enforcement officer a technique that is taught to people to use?
Yes.
Okay.
Yes.
And what are some, let's start with Agent Shadell. What are some of the minimization techniques that you see Agent Shadell use during this interview?
A specific technique that he used?
Or a specific question that he asked?
The one that I specifically documented, which was a minimization.
I don't mean to interrupt him. I just want to make sure he's not reading from documents for his testimony. That's all. He's got a notebook open. I just want to make sure he's not reading it.
You need to refresh your recollection. You just let us know, but thank you.
Okay. Don't read from anything. If you need to refer to something, that's fine, but just don't read. Thank you.
Yes, sir. I'm sorry.
Thank you, Mr.
It's okay. Any specific minimization statements that Agent Shadell said that you can recall?
So the one that stands out to me the most is when after Ryan had given his account of in the house, stealing from her purse, hit her, and she died. When Jason refers back to that to him, he refers to it as an accident. That's a minimization.
Okay. If Agent Shadell made statements to Mr. Duke about him not being a monster or something of that nature, would that fall within minimization?
That would.
It would not.
That would.
It would. Okay.
Yes, that's a minimization as well.
Now, you specifically said a moment ago, though, that Ryan, Mr. Duke, is the first one to use this minimization in the interview. Is that right?
That's correct.
And have you noted, or do you recall, the minimization technique or the minimization statement that he used?
When he talked about burning her body, which is destroying her body, he used the word cremated. That is a minimization.
Okay. With taking a look at the transcript in this case, refresh your recollection on what the first one was that he used. Well, can I ask that? Was that the first minimization you recall?
That is the first one I documented.
Okay.
Or I noted. Sorry.
That's fine. Now, Is there also what we refer to as maximization in an interview?
It is.
What is maximization as it relates to an interview?
That is overemphasizing the evidence or overemphasizing the consequences if you don't talk to the interviewer or you don't give a truthful account. It's just like it sounds. It's making things bigger and worse than they really are.
In your review of this interview as a whole, the interview as a whole, did you note any areas in which Agent Shadell used this maximization technique?
I did not see any.
Okay. What about, have you ever heard of a phrase called assumption of guilt?
I have.
Can you tell the jury what assumption of guilt is as it relates to interviews?
It's basically a bias. It's basically from the agent perspective going into an interview is I automatically assume that you're guilty, and the way I ask my questions and the way I form my questions are always going to be leading questions that give you the feeling that you're guilty, and no matter what you tell me, it's not going to matter. I'm still going to see you as guilty. And it gives them the psychological thought process of why continue to talk? Why don't I just tell him what he wants to hear, and then I'll go home and the evidence will later prove me to be innocent.
Now, is assumption of guilt a technique that's taught, or it's something that is cautioned against?
It's just something that happens and is cautioned against.
Okay. In this particular case, is assumption of guilt an issue? Agent Shadell, does he have an issue with assumption of guilt?
No, he asked leading questions, but not in the form of not in the form of conveying to Ryan that you're guilty. Especially, again, because of the first minute and 30, there is no reason for an assumption anymore. Which again is why I told you that is so important, because without any techniques, without any tactics, without any mistake, we have the foundation of the admission, and from that point on, it's just a matter of understanding the details and then being able to corroborate those details.
Okay. If the interview, that first minute and 30, had not begun that way, and Agent Shadell asked some of the questions we hear him ask, would that have then caused you some concern about assumption of guilt?
It would.
Okay. When an interview is being conducted, are you, as the agent, in charge of that interview?
Yes.
When an interview is being conducted, as the agent, are you dictating where that interview goes, or are you allowing the person to tell their own story?
During the interview, you're allowing them to tell their own story.
Okay. Did Agent Shadell do that here?
Not completely.
Okay. And while we're on that note, let's talk about, again, seeing both sides. Were there things in this interview that, as someone reviewing it, caused you concerns?
Yes.
Can you tell the jury about any of those particular portions of the interview that jumped out at you as a concern?
So one specific one, again, because I'm looking for details and I'm looking for confirmation that was lost, is the way Agent Shadell asked, i.e. told Ryan about the cleaners where his folks worked at, and that's where the keys went. In his question, he told him every bit of this. So the only thing that was left for Ryan to do is confirm, deny, or I don't know. And that's not what we generally want to do. But that was the only place I saw that one specific thing that I said,
Okay. If the entire interview had been like that, would you feel differently about the interview?
I would.
Okay. And in fact, as a result of that, did you list the dry cleaners and his aunt working there as a confirmation or corroboration?
No.
Okay. Let's compare that, a situation where Agent Shadell gave him, as you said, all of the information, to the situation of the phone call. Who is the first person in the interview to introduce that a phone call was made?
Agent Shadell.
The fact that Agent Shadell is the first one to introduce this phone call, does that change your opinion or the importance of the guilty knowledge?
It does not.
Why is that situation with the phone call different than the situation with the cleaners?
Because from there, and Agent Shadell passes that in the form of a question, which sometimes is unavoidable. If I'm going to ask you about a specific phone call, somehow or another, I have to direct you to understand what it is I'm talking. So some of these things are, in terms of passing information, is just unavoidable. But with that question about a phone being made, Ryan is the one that talks about it being a payphone. Ryan is the one that talks about it being the G&G in front of, or the payphone in front of G&G. Ryan is the one that talks about calling 411 to get connected directly to Tara's house.
And in the case file, were all three of those, actually, I guess four of those, that it was a payphone, that it was at G&G, that it was in front of G&G, and that it was a 411 call, were all four of those things corroborated by the evidence?
Correct.
While we're talking about the payphone, in your analysis of this interview, did you note any items that, and I'm going to use your word and then we're going to explain what this is. Did you note any times of what you refer to as deceptions?
I did.
Okay. Can you explain to the jury?
I thought we discussed this.
Okay, so again, understanding this is the word you used in your report, I want to be clear on what you mean by that. In your report, the times that you note and use the word deception, is that based on Ryan changing his statement later?
Yes.
Okay. And so again, I don't want to talk about your opinion, but are we talking about what Ryan actually says?
Yes.
Okay. And I don't want to talk about all of those, but how many of those did you note where Ryan says one thing and then changes it based on questioning from Agent Shadell?
3 times.
Okay. Did any of those involve the telephone call?
Yes.
Okay. So tell us your recollection, or tell us why that was important to you to note that there was, again, under your definition, that he then changed what he said about the telephone call. Why is that something of note as it relates to these interview techniques?
Because again, Jason has to ask him if he did anything else, if there was a phone call made. He initially says no. Jason has to tell him, we know there was a phone call made. So he has to prove to him that he knows there was a phone call made. And then Ryan responds to that once he realizes, okay, he knows that he made the phone call from the payphone.
Okay. In a situation like that, exactly what you're talking about, is the fact that Agent Shadell is using leading questions inappropriate or improper?
It's not.
Okay. Go ahead.
It's not. Again, it's what you got to understand about, well, here's what you got to understand about interviews and interview training. The interview training is a plan, so that you have a plan when you go talk to somebody. But it doesn't always go just the exact way that it looks like in a laboratory or it looks like in the classroom. And here's why. The interviewee didn't come to the training. They're not playing along. They're not always playing along with the plan. They don't understand the plan. So it works really good, and it looks really nice in controlled situations, but on the streets, it don't always play out just like that.
Okay. In this particular interview, are there ever times in which Agent Shadell confronts Ryan, such as he did with the phone, and Ryan corrects him?
Yes.
How many different times did you note that Ryan Duke corrected Jason Shadell?
21 times.
Okay. And specifically, and again, I don't want to go through all of those just for brevity's sake, but have you noted each of those 21 times, as in written them down somewhere?
I have.
Why is it important to you in evaluating this interview, or is it important to you in evaluating this interview, that Ryan Duke corrects Jason Shadell 21 times?
Because it's extremely important, because it tells me that Ryan wants Agent Shadell to get it right. I want you to have the right information. What you just said is wrong. Here is the right information.
Okay. And again, I don't want to go through all 21 of those. Do you recall a time in which Agent Shadell told Ryan Duke, "You're doing the right thing"?
I do.
Did Ryan Duke accept that statement, or did he correct him?
Do you mind if I look back to that specific one?
Certainly, if you need to refresh your recollection. I'm going to move that microphone from underneath.
Okay.
Okay. So when Agent Shadell says, "You're doing the right thing," what is Ryan Duke's response?
No, sir, I'm not.
And how quickly into the interview is that correction?
Very quickly. 2 minutes?
Okay.
Just over 2 minutes?
Do you recall a portion or a time in which Agent Shadell makes the statement, "Part of what you did led into her being missing," right?
I do remember.
And did Ryan correct him at that portion?
He did.
What was the correction?
She died.
And again, just to clarify, because I don't want to be nitpicky, we don't want to sound like we're being nitpicky, why is that considered a correction?
Because Agent Shadell is talking about her missing. Again, that's a good example, another good example of a little bit of a minimization there. In Ryan is saying, "No, man, she died."
Okay. What about, is there a time in which Agent Shadell suggests to Ryan Duke that he went back to the burn site multiple times? And if you need to refresh your recollection, that's fine.
There is a time.
Okay. Do you recall if Ryan Duke corrects Agent Shadell then?
He does.
And do you recall what he says to correct him?
That he only went back one time.
Okay. And do you recall what he says about why he went back that one time?
To put the household garbage trash we talked about earlier.
Okay. And again, I'm not going to go through all 21 of those, but as it relates to the confessions, the majority of those the corrections, the majority of those 21 corrections, would it be fair to say that many of those are also statements of responsibility?
That's the statement.
Or is there any, and we're going to talk about what a statement of responsibility is in a moment, but is there overlap between the statements of, the statements of correction versus the statements of responsibility? Is there any overlap?
There are. There's some overlap in a number of these sections, but yes.
Okay. So then let's move to what you refer to as statements of responsibility. Can you tell the jury what you mean by a statement of responsibility?
That Ryan made a direct statement taking responsibility for the murder of Tara.
Okay. Now, did you note any times in which Ryan made what you refer to as statements of responsibility?
Yes,
How many times?
6 times.
As it relates to those 6 times, were all of those based on prompting from Agent Shadell?
No,
How many of those do you know, if you know, how many of those were based on prompting by Agent Shadell when he made the statements of responsibility?
only 1.
Okay. So 5 other times we're talking about that he, without being prompted, makes statements of responsibility?
That is correct.
Any of those statements of responsibility that he makes, did he ever make those statements in reference to burning her body?
No,
So all 6, including the one that Agent Shadell prompts, what are they about? What is he claiming responsibility for?
the murder of Tara Grinstead.
Okay. Why, when you're analyzing this particular, or any interview, why is it important to look at statements of responsibility?
Because he's taking responsibility for the event in which he's being interviewed about. He's not only talking about it, but he's also taking responsibility for it. And again, common sense of our everyday walk in life is that's very important.
Okay. Again, and then analyzing this, is that an indication of any particular type of pressure?
Internal pressure.
I'm sorry?
Internal pressure.
Okay, and again...
Feeling guilty.
Go ahead.
Feeling guilty.
Feeling guilty. So, then, going with that, are there any specific statements of guilt that are made by Ryan Duke in this statement?
I don't understand your question.
Sorry, did you note any, what you refer to as statements of guilt in this interview? Apart from statements of responsibility, statements of guilt.
Internal?
Yes.
I'm sorry, yes.
Sorry.
Yes.
Okay.
Internal pressure, yes.
And how many of those statements did you note?
16.
Any of these statements of guilt that you can recall, and again, if you need to refresh your recollection, please do, of any of the 16 statements of guilt that he makes, Ryan Duke makes, do you recall him ever specifically expressing this internal guilt about burning Tara Grinstead's body? Does he ever make any of these statements?
I sustain that objection.
Can you take a look at those for me and tell the jury, are there any times that he makes any statements of guilt related to burning Tara Grinstead's body?
Sorry, I'm a slow reader.
Yeah, you're good. Though it is after lunch.
No.
Okay. Are there any, having looked at that, can you tell the jury, are there any statements of guilt that he makes about specifically murdering her?
Specifically murdering her?
Well, that he references that the guilt is based on having committed the murder.
Yes.
Is it once or more than once?
I'll have to look back.
Okay, that's fine. Let me ask you this then. Having had a chance to look at that, do you recall And can you tell this jury if there are ever times at which he references feeling guilty because things could have been different if he had not left?
Objection, meeting.
Overrule that.
Thank you.
Yes, he does.
Okay. Can you tell the jury when he says that and what he says?
Can I go back?
Yes, you may take a look at that to refresh your recollection. And I'm just going to move you along here. If you could look at the first interview, 38 minutes and 31 seconds for me, based on your notes.
Yeah, well, there are actually two.
Okay. So can you tell the jury what those two are?
Not answer from a document.
I'm just trying to get it right in my mind so I give them the right information.
Okay.
It takes me a minute. I apologize. I don't want to say the wrong thing. That's why I'm being slow. Yeah, it's not that I hadn't found it. I just got to remember it. It's long.
And it is long. I don't need the whole thing, just the portion where he talks about it not leaving.
So the first time, which is about 38 minutes in, he's talking about things could have been differently. Things could have gone differently had he just not left.
Okay. And specifically, in the context of that, he's talking about not leaving where?
Tara's house.
Okay. And then you said there's a second one?
Yes, in part two, a little over 19 minutes, he mentioned he could have done the right thing then and there.
Okay. Now, shift gears again, and we're almost done. Talk to us about statement content analysis, please.
So statement content analysis is basically training that taught me how to dissect words, how to dissect statements, but even more specifically to dissect words that for me, and again I'm gonna keep this simple, that it didn't make me a walking human lie detector, because I'm not, but it did give me a pointer system that as I'm looking at a statement and I see certain terminology, that it points me to an area that I circle and I say, okay, this is important, or we have a problem here and you need to ask more specific questions in this area of their statement. So all it is a pointer system that directs me to an area to ask more questions.
Okay. And have you received training in this area?
I have.
And is this something that you commonly use in either your own interviews or in reviewing other person's interviews?
I do.
Okay. In this particular interview, can you tell the jury, is there any one specific statement that the defendant makes that we've discussed that it involves this statement content analysis?
So it jumped out to me when Ryan mentions the quilt. So Jason's asking, or Agent Shadell's asking Ryan how he moved the body outside the residence and where he placed it in the truck. And the common way to answer, and this is what we're taught in scan, the common way to answer is just the easiest answer that answers the question. Anything you add to that that's beyond the question is important to the speaker, and it's my job to figure out why it's important. I don't know why it's important. but I would circle it and say, that's important, I just don't know why. Because Ryan gives the answer, but then he adds that he wrapped her in a quilt.
Taking all of this into account that we've been discussing, read technique, the minimization, maximization, assumption of guilt, confrontation, all of those things we've been discussing. If a suspect walks into a room with the intent to make a false statement, do these things ever come into play?
For the same reasons we have before.
Judge, the testimony of the defendant was that he walked into the room with Agent Shadell.
I overruled that.
If a suspect walks into a room and intends to give someone, an officer, a false statement, do we ever even need to talk about techniques?
I don't understand your question.
If a suspect is intending to lie to an officer, would it matter if the officer used assumptions of guilt improperly?
Okay, you're talking about interview techniques?
Yes.
Okay. Not in terms of it being a bad thing.
Okay. And if the person walks in there with the intention of giving a false statement, would it matter if the officer uses minimization? Would it influence, is it going to affect the interview in a negative way if the officer uses minimization when someone has already intended to lie? Would it affect? Thank you. You want me to restate it?
Let me answer this the only way I know how to answer it.
Okay, so I guess let me be, sorry, I'm going to rephrase it then and let me be more clear. Assuming that Ryan Duke walked into the interview room with Jason Shadell on February 22nd, 2017, and intended to lie to Jason Shadell, with that assumption, would any of the minimization techniques that Jason Shadell used have created a false statement themselves?
No.
Okay. And why is that?
If he's intending if he's, to your, I don't understand your question.
Okay.
Because you're asking me about someone in an interview that's not telling the truth.
Correct. Someone who's already not telling the truth. Is minimization going to be a problem that's going to create more untruths, or they've already decided to tell it?
It's not going to create more untruths, no.
The things that we talked about related to corroboration, that specific technique of going through and building on that foundation, is that a technique that can be used in situations to, if someone has already intended to make a false statement?
Yes.
No further questions.
Yes.
here again, go discuss the testimony you've heard. We'll be back after lunch, probably, around almost 1 o'clock, about 2 o'clock. So enjoy your meal, and we'll undertake the cross-examination of Mr. Posey after lunch. Thank y'all. Thank you. Okay. You can have a seat, Mr. Posey. Thank you. All right, we're ready for the jury? Ms. Watkins asking them to join us. Thank you.
Special guest, if you have to.
I did. All right. Thank y'all. We all, everybody cool enough, I guess? How about cutting that air, if you can help us with that, Mr. Whitley? Thank you. All right, ladies and gentlemen, we'll start off this afternoon with the cross-examination of Mr. Posey. Thank you. Please proceed, Mr. Merchant.
Inspector Posey, is one of the first goals in the interview to gain rapport with the interviewee?
Yes, to gain trust.
And the purpose of that, I thought I heard you just say, is to gain the interviewee's trust?
Yes.
And to get them talking?
Yes.
And that's why you use open-ended questions?
Correct.
You're not supposed to ask questions that suggest the answer?
That's correct.
Because the interviewee can be susceptible to leading or suggestive questions.
That is correct.
The purpose of a leading question is to control the conversation.
I don't know that's definitely something that can happen, but I don't know that's the only reason that does happen.
But it's a way to introduce information that has not been offered by the interviewee, Mayor.
Well, you do that.
You introduce information in a leading question.
Yes. If you're asking a leading I mean, there are leading questions you can ask that doesn't introduce anything that's of importance, such as evidence. But if you do that and there's evidence in there, like we talked about with the phone earlier, then yes, that happens.
All right. And did you take a look to see whether or not Agent Shadell introduced information in the interview?
The biggest one that I did, the biggest one that stood out to me again was the where he, in his question, he told Ryan about the cleaners, and that's where he disposed of the purse and the keys.
He also introduced the idea of the credit card.
He did.
Right?
He did.
That was information Ryan had not offered.
Correct.
He also introduced the fact about Ms. Grinstead's house, the location of the crime scene, correct?
I don't remember that. He was not the first one to mention Tara. Ryan was the first one to mention Tara. But in terms of who first mentioned a specific location, I don't know.
Would you defer to Agent Shadell if he had testified about that?
Judge, I'm going to object. Sorry.
I'm sorry, go ahead.
So the question was, would you defer to Agent Shadell if he testified about that? I'm objecting to asking him to comment on someone else's testimony. Because he hadn't heard.
Yeah, I'm not asking him to comment on the credibility of Agent Shadell. I'm just trying to figure out if he thinks that Agent Shadell would be in a better position to answer the question.
That's exactly commenting on Agent Shadell's testimony and whether or not he believes it.
It's not based on...
Yes, I know, I will rule that.
And so, sir, is it important for the agent to clarify any inconsistencies from the interviewee's account against other witnesses or evidence with additional specific questions?
It is.
That's from your report, right?
Yes, sir.
To use your house analogy, you don't want to build a house on a shaky foundation. Is that fair?
Well, for that specific things, that would be part of building the house, is getting the details and making sure the details are right. So that would be beyond the foundation, but just kind of flip the analogy around, and yes, sir, we agree.
So the whole point of following up on the inconsistencies is to make sure that you can resolve them as part of your interview.
Make sure your details are correct.
And if the details are inconsistent with the person's account, you need to do some more digging. Is that fair?
That's fair.
So in your words, I think you said you're looking for, quote, confirmation of details. Is that true?
Yes.
Do you know how many times Mr. Duke said, "I don't know," during his interview with Agent Shadell?
I do not. I did not count that.
If I told you it was 55 times, would that surprise you?
I know it was a lot.
And the fact that he said, "I don't know," does that lack of knowledge create gaps in terms of the agent's ability to corroborate the information?
It could.
And in a case where it was 55 times, there's a good chance you probably need to ask some more questions or do some more digging.
And I can recall some situations where, specifically where Agent Shadell was talking to him about how he got to Tara's house, and he responds, "I don't know." And then that's when he asked more questions, and his story changed to he stole the keys from the pockets.
But it creates gaps that have to be filled in eventually.
If you don't ask specific questions just like that to clean it up, yes. But you also got to understand, again, it doesn't, within an interview, as I talked about earlier, training in controlled environments, it looks one way. When you take it to the real street, yes, you want to learn as much as you possibly can, but it doesn't mean you're ever going to learn everything. Like in the end, we would like to know everything. It just doesn't always work out that way for us.
And I understand you may not learn everything, but you should at least try to learn as much as you can.
I agree with that. I agree with that. I do.
As part of your work on this case, did you come to learn how many locks Miss Grinstead's front door had?
I did.
How many does it have?
One.
So can you see the photo I published? This is previously admitted as State's Exhibit 76.
I do.
All right, sir, can you see whether or not there's a hotel-style lock above the lower door handle lock?
Above it? I don't know what that is.
You don't know what that is?
I don't. From that picture, I don't know what that is.
You can't tell that that's a lock?
I don't know what that is from that picture.
Okay. Well, let's assume that that's a lock that can only be locked from the inside. We've had some testimony about that. Can you assume that with me?
Okay.
So would that be an important inconsistent fact if Miss Grinstead, if there was testimony that Miss Grinstead always locked that door or routinely locked that upper lock when
But
she
I'm
was...
going to object to a hypothetical that is not based on evidence in this case. That is completely an inaccurate statement of what the evidence has been related to the top lock.
It's been a little conflicting, but I'm going to rule that objection. Go ahead.
Sir, if they're assuming that she locked that upper lock when she was home at night, okay, with that fact, if that were true, would that be inconsistent with Mr. Duke being able to gain entry into that house using a credit card only on the lower lock?
Yes.
And the credit card, do you have personal knowledge as part of your investigation about whether Ryan even had a credit card at that time?
I do not.
And as a GBI official, are there ways for GBI agents to obtain records that would confirm that one way or the other?
If he personally owned a credit card at that time?
Yes.
I would think through a credit history report that you could learn if they have a card at that point.
And if he didn't have a credit card at that time, would that also be in conflict with the story he gave that he used a credit card to get in the house?
I wouldn't go as far as to say that, because I don't ever recall him saying I use my credit card.
But it would be worth investigating. Is that yes, sir?
Yes, sir.
Okay. And I only say that because she can't take
I
down the
understand.
head
Yes, sir.
count, that's all.
That's my fault. I apologize.
So I want to turn to your testimony about there being no evidence of a crime, or being evidence of a crime inside. So the pictures on the wall, Ryan didn't reference that those were Miss Grinstead's, did he?
When he's being, yes, sir. When he's being specific to how did you identify her, and his response is pictures on the wall, that is a direct reference to her picture.
Yeah, I want to be more specific. I'm sorry, I asked a poor question. He didn't say those were pictures of Tara on the wall.
I guess I'm confused on how it would relate to him answering the question if it's not hers. I guess that's the part I'm confused.
He just didn't offer any information.
Y'all both got to speak up a little bit, okay?
He just didn't offer any information that the pictures themselves depicted Miss Grinstead.
Again, I believe with him answering the question in the manner that he did, he's telling you it's Tara's pictures.
But that's not a particularly specific piece of guilty knowledge, is it?
That was in independent collaboration, not guilty knowledge.
Okay. But in any event, most people have pictures hanging on their walls inside their house, right?
I would say that that's common.
You had testified about the blood on the comforter.
I'm sorry, I just can't see what we're looking at.
Yeah, I'm going to identify it. This is State's Exhibit 120, sir. Can you take a look at that?
Yes, sir.
Is that the blood on the comforter that everyone's been talking about, that you've been talking about today?
Is that the comforter on her bed?
Yes, sir. Is that the blood that you talked about earlier on the comforter?
That is the blood that I believe was referred to in the summary and that is consistent with the picture that I saw.
Okay. Well, let me ask you this, sir. With all your years of training in the GBI, is what we're looking at consistent with a fatal blow to the head that causes bleeding?
And I am. I'm going to object at this point as it relates specifically to, just because the way the question is asked, I think it calls for a medical conclusion. I think there is a way to ask the question that you would probably know the answer, but what he has asked is that consistent with a fatal blow to the head, which I believe calls for a medical conclusion.
I'll try to rephrase, Judge. Let me see if I can break it down. And can you let me know if I can't? If I'm not being heard over there, I promise I don't project particularly well. Not much of a screamer. So, sir, I want to sort of focus in on these couple of areas on the comforter. Does that look to you to be consistent with what we would refer to as menstrual blood? As a crime scene person?
I have no way of knowing that.
So in terms of your review of the interview in this case, where Ryan says he struck her on the head once and that she died, if you're using the blood that we're looking at here as evidence of that, is that what you're doing?
No, sir.
Are you suggesting to the jury that this is evidence of a crime, or are you not doing that?
No, I was not. I was only pointing out that in my statement, to be completely transparent about the part about the scene where Ryan said there's no blood at the scene, and the crime scene specialists find no blood at the scene, to be 100% to not appear to be misleading, but understand there was some blood found on the comforter.
But you're not.
But I'm not saying anything specific about that blood.
Okay, you're not suggesting to the jury that it's evidence of a crime?
No. No, sir. I apologize.
And I think I understood your testimony earlier, but there's no physical evidence that anyone was killed inside the house, to your knowledge, from your work?
Not from my assessment of just the crime scene.
In the course of your work, sir, did you come to learn whether the front door was unlocked or locked on Monday morning?
I don't know the answer to that.
Well, if the door was locked on Monday morning, would that suggest to you a fact that someone had locked it from the outside on the way out?
On the outside?
If the door handle, the doorknob was locked when people first tried to make entry on Monday morning, would that suggest to you that whoever went out last turned around and locked the door?
No, sir. It would actually, that's a possibility. But since I've done this before, to break into my own house, if I use the card, all it does is move the latch. It doesn't turn the latch on the back of the doorknob. So it'll still be locked. It just moves the latch away from the impression in the door frame.
But the door, whoever went through it, the door was locked when they left. Is that fair? As an investigative fact, that'd be something you either know or you have to follow up on.
I don't know. I don't know if it was locked or not.
Well, Ryan said in his interview that he went back to the house around 9:30 in the morning, or the morning of Sunday. Do you remember that?
I remember there being some discussion about time, but I did not recall them really hammering down a good hard time.
But he went back to the house. In his interview, he said he went back to the house to get her body, correct?
He did.
And Agent Shell suggested that's when the glove was dropped, right?
Correct.
So if he goes in to get her body, carries it out in a quill, puts it in the truck, do you believe him doing that, he'd be able to see a glove sitting on the ground?
Well, to use his to take his own words is just a big mistake. I have no idea if he can see it or not.
Well, if he had to lock the door, if he carried her out and put her in the truck, and he had to go back and lock the door, that'd be two opportunities for him to see the glove, right? If he dropped it on the way out.
See, again, I'm held up on him having to go back to lock the door, because again, if we're going to because we're doing a lot of assuming here. If we're going to assume that his statement is correct, and he uses a credit card, the door's still locked. So you don't have to go back to do anything. You just have to pull the door shut.
And I'm not suggesting that we assume anything. I'm asking you questions based on things we know in the case evidence and whether or not those create inconsistencies with his story.
Well,
so let me.
Okay, I guess I got confused when you made the statement that he went to the truck and then came back to lock the door. How do we know that if we're not doing some assuming?
Is that a fact you could have asked, or someone could have asked Ryan about in the interview?
It could have been asked of him in the interview.
Are you aware of testimony from Larry Peterson, a GBI trace evidence person, who told this jury that it's highly unlikely that the fibers found on the glove would be from a blanket or a quilt?
I don't know anything about testimony from Mr. Peterson.
But if that were true, would that create another inconsistency in Ryan's statement?
That if the fibers found on what are inconsistent with the quilt?
Glove.
What quilt?
It would create another question that would have to be followed up on. Fair?
They're inconsistent with what quilt?
Larry Peterson told us that there were fibers on the glove, and that on questioning from the state, said it's highly unlikely that those fibers are consistent with coming from a blanket or a quilt. If that's the case and it's true, doesn't that create another inconsistency in Ryan's story that would need to be followed up on?
If that were true, but if we don't have the quilt and the blanket, I don't know how you say that it's not the same. I don't understand that.
But my point is, you'd have to go find out.
If you can find it.
So Ms. Grinstead's car, I want to talk to you about that. Did you develop information about Ms. Grinstead's car at all as part of your work?
No, sir.
And I know this was not an issue that Agent Shadell focused on in the interview, but did you find anything as part of your work important about the car?
I didn't review anything about the car because there were no statements made about the car.
If you learned that Ms. Grinstead always locked her car door, but that on Monday morning when it was first opened, it was unlocked, would that create a question that would need to be followed up on?
Yes, sir. And the best person that can answer that is Ms. Grinstead. And from there, it's going to get difficult.
Right, but doesn't it also create an opportunity to ask Ryan another question about the car?
Absolutely. Anything can be asked of Ryan if in that moment you are aware of it or think about it. I agree.
And so Ryan told Agent Shadell he didn't really remember the car. Do you remember that?
No, sir, I don't remember that.
And if there was money found in the car that was unlocked, and Ryan's story was that he had gone to her house to burglarize her, would it be inconsistent that it would be a burglary if there was money available in the car?
Not based on what I know. And again, my knowledge is very, very limited from just doing the assessment and the crime scene. So I'm very limited, and you're asking me some very broad questions about many other areas that I did not look into, but the only way I can answer your question is not that I know of.
There's also been testimony that her car was not at her house until late Sunday, even though Ryan indicated in his statement that this happened Saturday night. Do you agree that he said this happened Saturday night in his statement?
I remember him being, yes, I remember him being a little confused. Jason, or Agent Shadell, is the one that introduces Saturday, Sunday, not Ryan, but I do remember Ryan did not correct him, so Ryan's recollection was that actually it was September, late fall, was his recollection of it, but he definitely did not correct Agent Shadell.
So if Ms. Grinstead is home inside her house and the attack allegedly happens in there, and her car is found late Sunday, and there's testimony that it wasn't there during the day on Sunday, would that create another question that you would need to follow up on in terms of trying to evaluate Ryan's statement?
That's a judgment call from the agent doing the interview at the time, especially if, as you just told me, because I don't know this, he already said, I don't remember anything about the car. That agent in that moment could easily make a decision that if you don't remember anything about the car, there's no reason to continue on with that line of questioning.
But that wouldn't be true if you had knowledge that it was unusual for her car to be unlocked, especially if she's not there, right?
Again, that's a decision that agent has to make at the time based on what you've told me that he's already. I don't know what question is going to keep coming after that if he's already said I don't remember anything about the car.
He couldn't ask him, hey, her car was unlocked. Do you know anything about her locks?
I don't remember anything about the car.
But isn't part of what Agent Shadell did here continue to ask questions when he said I didn't know?
He did, but I guess what I'm missing here when it comes to the car within my assessment, within the assessment of what's being done at the time is I don't know how the car was important in the middle of that interview. I understand what you're saying now based on other things, but again, in the middle of that interview with the questions that Agent Shadell is trying to focus on in establishing the facts, what in that interview pointed him to say, let's focus on the car? He asks a question and gets a I don't know, but I guess I'm a little lost to second guess him sitting here when I wasn't there to say, well, he should have said this and he should have said that. Well, okay, sure, that'd be great, but I also can't fault the fact that he asked about the car, gets an I don't know question, and says, okay, there are more important things to me to talk about. Let's go to other important things.
But you just used the phrase that Agent Shadell was focused on that. I thought you testified on direct that the story should come from Ryan. Is that true?
You just confused me.
Well, I'm not trying to confuse you. You said Agent Shadell was focused. It wasn't relevant to what he was focused on at the time.
Meaning trying to learn. Trying to learn. Because there still has to be in an interview somewhat of a funnel effect of starting really, really wide. And you still got to make a decision on where that starting wide is. And there's a point where things have to narrow. Just like you asked me earlier about open-ended questions and then continue on. There has to be yellow lines on the road. There has to be. Sure, there's later times you can come back and second guess and say, well, then your funnel should have been this wide. Well, we can always do that. I promise you there's never been a time that I've sat right here and reviewed my own interviews and didn't think, I should have asked this and I should have said that and I could have done better here. That'll happen every single time.
So my questions are less focused on that and more on resolving inconsistencies in the statement versus the case evidence, and just trying to figure out,
yes, sir,
based on what your testimony was, what should be done in terms of following up. If you have information that the car was unlocked and that's unusual, that would be a fact you'd want to follow up on. Is that correct?
Yes, sir.
Is it fair to say Ryan was kind of all over the place when he was talking about the glove? In terms of his knowledge of the glove, where it came from, that sort of stuff? Was he sort of all over the place with that initially?
I would define the entire interview as being all over the place.
So one person has testified that they did not see a glove in her front yard at 6 o'clock on Sunday. If that's true, would that also be inconsistent with Ryan's story about going back Sunday morning to get her body?
Yes, sir.
And if another witness, captain in the police department, said he went to her house Sunday midnight and didn't see a glove, and that he thought he would if one had been there, is that also inconsistent with Ryan's story that the glove was there 9:30 or so, whatever time in the morning on Sunday?
If we make the assumption that this witness did not miss the glove laying there.
But that would be true if we assume they could see it.
We're having to assume that they should have seen it, and we're having to do a lot of assuming here.
Yeah, you present.
Sir, have you read the 2014 article written by Michael St. Ives entitled Interviewing Suspects?
I have.
What was your response? I'm sorry?
Yes, sir, I have.
Okay, sorry.
Okay. And I think you actually cited that in footnote 2 of your report, correct?
I did.
So the authors say that, quote, leading or suggestive questions are not only counterproductive, but also highly unlikely to contaminate a suspect's account. Would you agree with that?
Can be. Definitely can be.
So leading questions can lead to interviewer contamination of the account.
Definitely can be.
And I guess in the GBI manual, you talk about the reasons why people might lie. Is that correct?
In the GBI manual?
Yes. Does the GBI manual provide reasons why people might lie?
Be a little bit more specific. I don't understand your question.
With all of your experience at GBI, do you know or have you been told or do you teach others that they may lie for their personal safety?
It's definitely a possibility, definitely a reason.
And for the safety of their loved ones?
I've heard it before.
That's all I have, Judge. Thank you. Thank you.
Just a few very brief questions, Judge. In your training or your years of experience, have you ever known people to steal credit cards when they burglarize homes?
Yes.
Right. In your years of experience, have you ever known trained officers to miss important pieces of evidence?
100%. It's, as I said earlier, with my review, audio transcript. It's done because I know I'm going to miss stuff if I don't put them together. So, 100%.
In your years of experience, have you ever had just what we call lay witnesses, non-law enforcement officers, not see particular pieces of evidence?
Yes, yes.
In your years of experience, and now I want to talk about interviews, but specifically as to witnesses, have you ever had witnesses get confused about the dates that something occurred?
Yes.
Does the length of time between when the act occurs to when they are interviewed about the occasion that occurred, does the length of time between those two increase the possibility they could be confused about dates?
Yes, it can increase a number of things about their memory.
Okay. Defense counsel asked you questions about if Agent Shadell had heard or had known that fibers found on the glove were inconsistent with that being of a quilt, should he have followed up more questions about the quilt? Is that essentially the question you were asked, do you recall?
I don't think that was the question.
Okay. Do you recall being asked whether or not Agent Shadell should have asked more questions about the quilt?
Or maybe I misunderstood the questions. I thought the questions about the quilt were would this make Ryan's statement being inconsistent with Ryan's statement?
Okay. So I guess let me ask this differently. Do you recall or do you remember if Agent Shadell specifically asked Ryan if he still had the quilt?
He did.
Okay. Do you recall what Ryan's response was to that?
He did not have it.
And defense counsel asked you about the word contamination. And I know that we didn't use this specific, or did we use that specific word earlier when we were talking or when you were giving your direct examination?
I don't remember.
Okay, let me ask you this then. Do you recall if we gave the jurors examples from this interview of contamination?
We gave a specific example of contamination being when Agent Shadell told Ryan about the cleaners, and that's where the purse and the keys were disposed of.
Okay. And again, because I don't think I used that word earlier, trying to keep it simple, other than that area of contamination that you've already talked about with the jury, did you see, or based on your review of this interview, any other areas of contamination in your review of this?
Not when it was specific to the evidence.
Okay. And explain, if you can, for the jury why that part is important, that it was specific to the evidence.
Well, Agent Shadell may have asked leading questions, but if it wasn't specific to the evidence, which again, in my assessment, that's what I'm looking for. I'm looking for since I have that foundation of the admission of guilt, I'm looking for the details. Well, the important thing is the details need to come from Ryan. They don't need to be introduced or talked to Ryan by Agent Shadell. So that's what's important, is understanding that the details come specifically from Agent Shadell. Now, there are other things like the credit card that Agent Shadell does introduce, but there are also other things that were equally important and in connection with that Ryan introduced. So in terms of just saying that because Agent Shadell said this, we kind of need to slide that evidence over here and not consider it. The only time that I saw that was specific to the cleaners, the dumpster, the purse, and the keys. All one event.
No further questions.
Any follow up, Mr. Murray?
Yes, Judge, just briefly. Sir, do you remember that Agent Shadell had to ask Ryan 8 separate times about the glove before he admitted anything about the glove?
I don't remember. I didn't count those.
But would that be consistent with your memory, even if you can't remember specifically, around 8 times?
Honestly, I did not remember them discussing it that much.
So your testimony today is that you don't remember how many times he asked about the glove?
Correct. I do not remember how many times they asked about the glove.
But it was multiple times, if you remember, right?
Honestly, I don't remember.
So the glove is an important piece of evidence in the case?
It is.
And your testimony today relates to Ryan's knowledge of that critical piece of evidence in his interview, right?
Right.
But you can't tell the jury how many times roughly he talked about it before Ryan said yes, yes, sir.
Give me a second, please.
And sir, I don't need you to look for every single one. I'm just trying to make sure.
I'm actually going to object. He's asked the question, he's made a point to say you can't answer it. He has a chance to review his notes to see if he can answer it.
He's welcome to, Judge. I didn't want to waste everybody's time.
Go ahead. Let's take a second. Thank you.
Yes, sir. I definitely didn't record 8 times. No, sir.
Okay. Well, how many did you record?
Just from that brief look, there was two that jumped out at me.
The brief look over, what did you look at?
Transcript. So I started with so you'll see the highlight, you'll see the citation number behind where we talked about the gloves, which 26, that refers us to a specific area in the transcript, which is lines 14 through 16. What was my time again? Sorry. So I sort of have it underlined as being the first time it's mentioned at 1317. And then line 25, again, then they have the conversation about the gloves. And then the next page, they have a conversation about the color of the gloves. So that's, to me, that's all, that part, even though it's on 3 different pages, is all one conversation.
So you're treating that all as one?
Well, it's a continuation. I mean, again, like we talked about earlier, the whole interview at times is a little fragmented, so but yes, there's some coming back too.
Okay, so let me just close the loop on this for everybody. Is it fair to say that in that portion of the interview, the gloves are discussed several times?
Yes, sir.
And have you ever testified on behalf of a private entity or citizen?
No, sir.
All of your testimony has been on behalf of the GBI?
Yes, sir.
And you had 2 expert cases where you testified in trial?
2 other cases, yes, sir.
Okay, and was one of those with Ms. Hart?
No, sir.
None of those have been with this district attorney?
No, sir.
Thank you, that's all I have. Any further, Ms. Hart?
I do. So at the 13:17 mark, 13 minutes, 17 seconds into the first interview, did I understand you to say that's the first time you have seen that the word glove is brought up in the interview?
Yes, that's what I have in my notes.
Okay. And can you tell the jury what question is asked by Agent Shadell at that point?
Let me refer to it, please.
Sorry. I believe it's page 16 on the transcript.
The question from Agent Shadell?
Yes.
Tell me about the gloves. I know there's gloves in the house. Is it going to have your DNA on it?
And what is Ryan Duke's response to the very first time he's asked about the gloves?
It should. Because they were at my house.
Sorry, I interrupted you. Go ahead. What was the rest of it?
It should because they were at my house.
No further questions.
All right, Mr. Posey, thank you for your testimony, sir.
Thank you.
I'm going to excuse you at this time to go on about your business, all right? Thank you.
Thank you.
Please call your next witness.
Judge, I would, again, re-tender State's Exhibit 293, being a certified copy of Bo Duke's conviction out of Wilcox County in case number 2017 CRW 38.
Certified, you say?
It is.
Thank you.
Judge, we would just object on relevance grounds.
Okay.
We weren't allowed to cross-examine him, so we can't question him about this.
It's a certified record from a court of record. I'm going to admit it. I think that's it. Takes care of the authenticity. All right.
Your Honor, with that, we have no other witnesses and the state finally closes.
All right. Y'all need a minute, or y'all want to put up any short rebuttal?
No, we don't have any rebuttal. Thank you, Judge.
All right. Ladies and gentlemen, the evidence is closed. You've heard all the evidence you're going to hear in this case. I've got to go over the charge, which is the law that I'm going to go over with you tomorrow after the closing arguments. In a case such as this, both sides are entitled to 2 hours, up to 2 hours, to argue their case to you. I'm not saying they will, but they have that right under the law. After that, I will give you the charge. That is the law. And then you'll be asked to commence your deliberations. But until that time, don't deliberate, okay? Don't discuss the case with anybody. Don't allow anybody to discuss it with you, just like we've gone over before. As a matter of scheduling, I want to speak with them outside your presence for just a minute. And that is such a small room. Every time I walk in there, I can't imagine all 18 of y'all in there. Step out of the grand jury room for me. Maybe you'll be a little bit more comfortable, and I'll be right with you. Thank you. Please be seated. Where's Mr. Norton? Need Mr. Norton. Mr. Norton? Raise your right hand for me. You swear you're going to testify to the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. We spoke with the attorneys about it before we started back after lunch, but not on the record, so I want you to repeat for our record what it was two jurors spoke with you about over the lunch hour. And I don't want you to identify what they said to you and how it came about that you were approached.
They first approached me. If anything is going to be done about it. And I told him, I said, I can't give you any answer, but I will contact the judge and tell him of your concerns, which I did.
Thank you for handling it that way. Anybody got any questions for Mr. Norton about that communication? From the state?
Judge, the only issue that I would have, and I know the court was careful not to ask that, is we may need to have those jurors that asked him put that on the record, that they had noticed that the complaint came from other jurors, that they may need to put that particular thing on the record. So I think both defense counsel and state counsel have noticed it through the trial and have noted it repeatedly through the trial.
I would say, from our perspective, that's the only time I've seen that was today. I know one of the jurors, he tends to
Want to let him get off the chair?
Yeah, that's right, Your Honor.
Yeah.
One of the jurors that we're referring to, I know that even when we were doing voir dire early in the process, he has a tendency to, he looks down and he plays with his hair, twists his hair a little bit. So I've noticed that a couple of times. I have not noticed him, and I've not noticed the other juror ever nodding off or sleeping.
I noticed it particularly today and I don't know the numbers off the top of my head. I think maybe it's juror number, let's see, I can figure it out. Jurors number 71 and 78, and they're seated next to each other. I noticed, and I brought y'all, before the lunch break, I mentioned it to y'all. I did notice after you approached the bench and brought to my attention that after lunch, the same two appeared to be nodding off. Even after that, juror number 71, got his attention. And then it wasn't about 5 minutes later, the juror to his left was bumping him again already. So I'm going to bring Mr. Thomas in, that's his name, juror number 71, and question him. I'd be glad for y'all to question him if you'd like. Bring in juror number 71. Truth, whole truth, and nothing but the truth, so help you God?
Yeah, I do.
Thank you. You're having a hard time today.
Yeah.
Do you work at night, by any chance?
Well, sometimes.
Did you work last night?
Yeah.
I noticed this morning you appeared to be asleep. You think you nodded off this morning?
Yeah.
And again after lunch. Did you nod off again?
Yeah.
Anybody got any questions for Mr. Thomas?
Just a quick question.
Please.
It appears there was a limited amount of time that you were sleeping. Did you observe most of the testimony today while you were here with us?
Yeah.
Do you know what the last witness's testimony, what was his testimony about?
I had to look at my notes.
Okay.
Can we approach for just a moment before we continue? Sorry. Are the way they need to be, given that we have a juror on the stand.
Yeah, surely they're not.
I'm showing the judge and I'm showing you.
Great.
Thank you.
And then audio from the juror
Audio from the juror
is what?
The audio from the juror
Can be heard. Okay. Sorry, I just want to make sure we were that. So go ahead.
Oh, I was just going to ask, so you took some notes today?
Yeah.
Okay.
Any further, Ms. Hart?
No, I don't have any further questions. Thank you.
On some previous days in the trial, looks like you had nodded off a time or two.
Yeah.
All right. Mr. Thomas, I want to excuse you from the jury at this time. You're not in big trouble. Over your objection, I get it. You're in a spot with working at night, having to come down here and stay awake all day. It's critically important to both sides. And I appreciate your service, what you've been able to do for us, but you're going to be excused from the jury at this time. You can go on about your business, sir.
Your Honor.
Yeah.
May I make an objection on the record?
Of course, yeah, sure.
Thank you. Under the code that's applicable here, section 1512-172, a juror can only be excluded, excuse me, if the juror dies, becomes ill, or is unable to perform the duty. I've got a number of cases here, the Georgia Supreme Court and Georgia.
I've watched this juror sleep on and off for a week and a half. He's excused. Over your objection. I get it. Thank you. It's timely made, ruling preserved for the record. Thank you. He admitted he has to work at night, and slept through the trial on numerous days. All right. Anybody else? Any other jurors we need to question? Ms. Hart?
And I apologize if I had stepped out, but there is the other juror that's named who was pointed out by her fellow jurors.
Okay.
I know, I just would ask that we either question her or question the fellow jurors about the situation.
All right. Ask juror number 78 to step in. 78. Good afternoon, ma'am. You're not in any trouble. Just have a seat. Let me ask you a couple of questions. Raise your right hand for me. You promise or swear to tell me the truth, whole truth, nothing but the truth. So help you God?
Yes.
Thank you, ma'am. You had a hard time staying awake today, son?
Because I work every day.
I get it. I understand. Listen, I'm not mad at you or anything.
I tried.
Ma'am?
I tried.
Yes, you do. I'm not saying that you haven't. But have you just not been able to stay awake today?
Just today.
Just today?
Yeah.
Did you miss much of the testimony, you think?
No.
Okay.
I still took notes and I still heard everything.
Okay, so you weren't asleep then, is what you're saying? Oh, okay. Well, just from where I was observing, and even the attorneys approached before the break, and it appeared a couple of jurors was asleep.
I still heard everything.
You still heard everything? Good deal. Anybody got to ask or would like to ask this juror any questions?
No, Your Honor.
Okay. You confident you heard the testimony?
Yes, sir.
Thank you so much, ma'am. You can return to the jury room. All right, Mr. Rigby, do you believe it be appropriate to question the jurors who brought this up to the bailiff today?
Your Honor, I'm actually at this point satisfied with where things are. It may just be that we need to put on the record what jurors at some point, maybe not on television, but what jurors actually brought it to their attention so that that's on the record of those things.
Okay. Y'all want to ask the jurors that reported their concerns about the two jurors sleeping on the record?
No, Your Honor.
Okay. As I understand from what we discussed in chambers, the jurors that brought it to your attention were 18 and 64. Let's have the charge conference in about 5-10 minutes. Take a recess. We'll turn the air back on, please. Thank you. right, let's go over the charge, please. Where's Lindsay? It's all right. I'll find it. Request to charge first, please. All right. States 1.20 presumption of innocence, burden of proof, reasonable doubt. Everybody got the draft that I've provided them, I hope. What's in front of you should be from the pattern. Is there any objection as it's prepared in the charge now?
No objection.
All right, thank you. And comparing that then, Ms. Merchant, if you're up on your side, I got so much paper down here now. Here it is, defendant's request. That'd take care of your charge number 1 as well, right?
Yes, Judge.
Thank you. All right, state's request about evidence 1.3, as it's in the charge now, I think it's pretty close to the pattern. If y'all will take a look at it, it's the one I think I've made a modification or two just to try to make it sound a little plainer. Have y'all seen the plain language charge committee now that they're doing to try to make these charges a lot clearer, shorter, more concise? It's a lot better. Any objection to the evidence charge, Ms. Hart, in the draft?
No, you don't.
All right. Any objection, Ms. Merchant?
Which, is that number 6, Judge?
Number 6.
No
Just
objection.
take a look at it. All right. 6 is okay then, or the evidence is okay. And that is your charge number 4. 4 and 5, okay. 1.3, direct and circumstantial evidence, that's contained in the number 6 in the draft, so we'll mark that one off. Credibility of witnesses should be right out of the pattern, although I have charged it in the past with the consent of the parties to just tell the jury judging credibility of people is what you do all day, every day. Do that, but if y'all want me to take it right out of the pattern, I'm glad to do that. What's the state's preference?
The state's preference.
That's 1.31 for the states, and yours is requested charge number...
Should be 6, Judge.
Similar request in the defendant's.
But this came directly from the new pattern charges.
Okay, good. Let me pull it up.
But yes, that's what I was trying to do as well. So we
Take a look at that.
had just recently, thankfully, gotten. And I almost exclusively request patterns, so.
Well, that is the safest usually. Way to go.
suggested pattern jury instructions with the date of January 2022.
Well, that sounds like the most recent.
And we're talking about
13120.
Okay, so 1.31.0 did get repealed. This is 1.31.10, credibility of witnesses.
All right, I'm looking at your request. It says 1.31.20. This says there is no charge on this. Conflicts in testimony. So what you're talking about is credibility of witnesses. We got that in there. That's the jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances.
So you're, sorry, I apologize, I missed it. You're talking about .20, not .11?
The next one on your request to charge is 1.31.20.
I would withdraw that, Judge, I apologize.
I don't have, is the 11 is polygraph, right?
Yes, but there is a .20, but that is the former charge.
Right. It's taken out.
Correct, so I'm incorrect about that one.
No
I don't know
problem.
how I got it in there.
I'm sorry, I wasn't communicating with you. Expert witnesses, I have pulled right from the pattern. If y'all will please just scan that. I don't have it in this. Can you print another one, please? Good, thank you. Any objection to the charge on expert testimony as it's presented now?
No, Your Honor.
No, Judge. And that's the state's 1.3130
And you're
Seven.
number 7. Thank you. All right, now we're back to impeachment and credibility, prior statements. Please take a look as it's drafted now. It may need some more added to it.
Do you know where, is it in yours, Judge?
It's number 7.
Oh,
Right, maybe?
is it under credibility of witnesses, Judge?
Yes,
Okay, thank you.
should all be there together. Thank you, Lynn.
It's good for us, Judge.
All right. Is that acceptable then for your number 8, 9, 10 then?
Yes, Judge, for us.
All right, thank you. Ms. Hart, that'd be okay for your 131, 40, 45, I guess, and 47.
Sorry, man, just a moment, Judge, I'm just comparing it to the newest pattern.
No problem. It may have a little tweak in it.
It actually appears to be, it does appear different, Judge. Would you like me to read what 1.31.40 is, just so we can all decide?
Yeah, hang on just a second.
Certainly.
All right, 131.40. Go ahead.
May I remain seated? I'm reading off.
Yes, everybody, please do that.
In the and these are options: to attack, to cast doubt upon, to challenge the credibility or believability of, or to cause you to disbelieve any such witness. Those are all options the court can give.
Right.
This would include evidence of attempt to show character for untruthfulness. It also then talks about specific instances of conduct of the witness in question brought on across.
Yeah, I've got bias in there.
I did see that the bias and lack of bias is in there. We have had also
Who did that come up on?
Bo Dukes, because he was allowed to be called as a witness even though he took the fifth. They were allowed to tender to the.
Yeah, but no live witness was really.
Well. His embezzlement, yes.
Okay, thank you.
Or conspiracy, whatever.
I know you were talking about it, but I didn't remember you.
Judge, do you want me to go on to 13142?
All right, out of what you've just gone over, we'll add then the there is no other bad acts, right? Right?
No, Judge. No, Your Honor.
Bias is already in there. I'll keep that. Felony conviction I'll put in. Convictions.
I think that's a question for the defense, Judge. So
What's your preference? You want me to?
We might as well add it, it's not long.
I don't mind.
Okay, thank you.
Thank you.
the other portion, Judge, is of that is.
Give me just a second.
Sorry.
It's all right. All right, thank you. Go ahead.
It also specifically references in the main portion that it's not challenge credibility or believability or cause you to disbelieve any such witness.
You want to include all of that? I'm glad to.
I agree with Ms. Hart. I always think the pattern is the best
What
way.
did you say?
I know. Everyone, please take note. I think the pattern is always the safest bet.
That'll be fine.
To you if you'd like.
I have it right here. Thank you. And I will add that verbatim. Is in there?
Missing? Under section 7? Is that-
Yes.
Yeah.
This was specifically done by included by defense counsel, an attempt to do that. Under 1.31.42, witness supported, which I'm assuming is what you're talking about, prior statements.
I'm talking about prior inconsistent statements.
Okay.
Include character truthfulness and any lack of bias. I certainly don't mind giving that. I think it would certainly apply to Mr. Duke.
Thank you, Judge. We would ask for that.
All right. What about lack of bias?
specific instances of conduct of the witness in question brought out on cross-examination?
I don't know about any specific.
Otherwise, the fact that he told lies outside of what he claims he lied
And then
about.
we got the bad character evidence in there too.
And I guess just because we're going to be talking about character for truthfulness, I would just request that
Yeah, I'm sorry, you're right. Outside of the reputation
yes, Your Honor.
and opinion evidence.
And that was, obviously, some of those things can only be allowed in because the good character evidence was.
$131.40, the old impeachment charge?
I thought we were on .42.
I'm sorry, yeah, 131.42, excuse me.
Right, no, we have none to .42.
Great. All right, I'll add that. All right, defendants. Bottom of page 4, top of page 5. Let's see where my page 4 is. Yeah, number 9 in this draft. You'll please take a look at that. And that should be right from the pack.
That I'm not necessarily requesting it. I just want to make sure that defense counsel has looked at it and is not requesting it.
Necessity imposed by others. Yeah, it's parentheses. I'll put it if you want it, Ms. Merchant.
I thought you had that in part of yours, but if you
Well,
didn't-
I have it at sort of the bottom of, you know, it's all up to them.
yes, and we would.
All right, I'll put that in. Thank you.
I think number 12 is really number 10.
You think number 12 is really number 10?
The corroboration of defendant's statement. Unless I'm losing my mind with the numbers.
Yeah, we're not there yet.
Oh, okay, I thought that's where we were.
No objection from the state as to what Your Honor has under statement of defendant number 9.
All right, and that, as far as the numbers go on the pattern, goes all the way through 132 point, skips over the juvenile,
I think 5-0, Judge?
skips over the, yes, all the way through 5-0. Down to corroboration, 132.7. Let me mark these real quick. So, one's a circumstance. All right, as to the defendant's statement, then, Ms. Merchant, I'm checking off your charge request, 14, 15, 16, 17, 18, 19, and 20. So we're down to, it's the same request. 132.70 is your 21. It should be right out of the pattern as it's in there. You'll please double check that for me. Which is 12, like you said. My numbers are going to be off here in a minute. Ms. Hart, you okay with the corroboration of the
Yes, Your Honor.
defendant's statement charge?
Yes, Your Honor. Looks like it's straight out of pattern. Yes,
You
Your Honor.
okay with it? Good,
Yes.
all right. We'll
Thank
leave
you.
it in as it is now. All right, next, identification. I don't think you made that request, did you, Ms. Merchant?
I didn't.
All right, how's that,
If they're not
You think it's-
requesting the burden of proof for identification, Judge, then we're fine with that not being given, but that is in fact something we have to prove.
Can give it,
And this is not the one, I guess I should say, this is not the identification charge that relates to out-of-court identifications.
Right.
It relates to the identification of proving that the defendant is the one who committed the crime.
all right, this is 13511 we're talking about. Let me get, I don't have it in here now. Let's take a look at it.
1.35.11, yes. No, we would ask for that one, but not the other one.
Okay. Defense wants 13511, right?
Yes, Judge.
All right, I'll give that. All right, next on the state's list is 13520 and, 13520 and then 13530, fingerprints and DNA. They should be right out of the pattern as they exist in 11. I got two 11s. Fingerprints, the first 11, and DNA evidence is 11B, which I'll of course change, but y'all take a look at that. It should be right out of the pattern.
Oh, this is a pattern. That's why I'm doing that. Judge, may I,
Go ahead.
sorry, the only thing that we would ask is, at least in the beginning or at some point in the charge, when it references fingerprint, perhaps have something in their fingerprint and/or palm print, just so it's clear, because the testimony was that it actually came from, they believe, from the palm. I don't want the jurors to take it too narrowly. I don't know that it has to be added every time, but just to clarify.
I don't have any problem with it.
Or you could just say print evidence, either way.
That'd be a good solution. All right, so look okay otherwise on fingerprints?
Yes, Your Honor, thank you.
Ms. Merchant?
Yes, it does. Thank you.
Thank you. All right, what about DNA? Y'all have had a chance to look at that?
No objection from the state. No objection.
All right, that's 11B on the list, 3530 on the states. Your request to charge number 25, we'll check off, Ms. Merchant. All right, next on the state's list is 13615. I did not add that in.
We didn't think it applied.
It doesn't apply anymore, Judge. We had asked for that originally, not knowing if we were going to call Garland Lott in our statement in chief, or excuse me, in our case in chief, which we didn't. And so Garland Lott's testimony was actually admitted as a prior inconsistent statement.
13615 is withdrawn then. Good
Yes, Your Honor.
character is the state's next, 13710.
We would ask for that as well, Judge.
I think it's, do you have any?
And the traits, I had asked Mr. Gibbs, I think it was peacefulness and truthfulness.
Thank you. That's my recollection too. That should be right from the pattern.
Looks like it does. Looks like it does too.
All right, Ms. Hart, peacefulness and truthfulness as the particular traits. Evidence was offered of. Any objection to those?
No, Your Honor. I put that in there just because we want to make sure doesn't get left out and there's error induced. So whatever the defense counsel wants.
Yeah, I think that's perfect. I know you would have brought it up, but I don't see it in one of your specific requests, Ms. Merchant, but we'll certainly add that.
Thank you, Judge.
All right, definition of a crime, 140.10, that should be back on the first page somewhere. All right, let's see. Yeah, number 4. But I haven't checked to see if that had changed since the last version.
That's number 4, Judge. On page 2.
Straight from the pattern, Judge.
Okay, we'll give it as it's in number 4 and check that off both lists. Thanks. Intent is next, right under it. Number 5 now on page 2. Please double check that one. That also encompasses your 28.
That's what I just noticed. Thank you, Judge.
Does that check out all right with you? The intent charge, Miss?
It does, Your Honor.
Okay. We'll check those off. Thanks. All right, venue, state's requested just the general venue charge, and I left that in there, but I've also added, Ms. Merchant, your request as to special circumstances. There was a number of choices through the pattern. I picked out 2 of them, I think, if you'll take a look at those and see if those are satisfactory.
Yes, Judge. I read those, they are. Thank you.
All right, Ms. Hart, I think I left italicized what I wanted to specifically bring to your attention.
And that's from a pattern, too. Ma'am, just a moment, Judge.
Yeah, that's on page 10 under number 13
All right,
from the draft.
Thank you.
I mean, it's a proper statement of law. I suppose it goes along with their argument.
I think it'd be appropriate to give it. Any objection from the state?
No, Your Honor.
All right, thank you. All right, let's go back to, let's see, we got at the bottom of your first page, top of the second page of your request, Ms. Hart, looks pretty specific to the charges. So let me go through some of these other evidentiary. Accident is your request number 29. Ms. Merchant,
Yes.
is that, you still request that?
I'm flipping back through where.
I've got it there listed as one of the number 12s. It's at the top of page 8. It's not, I mean, your theory is we weren't there, right?
Right, exactly.
So it'd be appropriate to take that out?
We can take that one out, Judge, yes.
All right. All right, so your request to charge number 29 is
Withdrawn.
Withdrawn, thank you. I did not include the knowledge request. I don't mind. It was one that I had down at the bottom that I could just cut and paste and move on up. Is the defense still requesting number 30?
I believe it's number 12 on your page 14. And
It is.
We are requesting that, yes, Judge.
Ms. Hart?
Sorry, ma'am, just a moment, Judge, just want to make sure I'm correct on what the pattern says on that. So if Your Honor is going to give that charge, we would, and I may have requested, I just don't recall it, but if Your Honor is going to give that charge or knowledge, we would ask that the court also then give charge on parties to the crime.
Judge, he's not charged as a party to the crime.
The statute doesn't require it, and the charge actually says that in the statute.
Judge, there's been absolutely no evidence whatsoever to support a party to a crime charge.
Well, he could, it would be a party to the crime of concealing the death.
In Ben Hill County.
Ma'am, Judge Garlemont testified just today that he heard whichever one of them say it, joke around that they together killed her and they together burned the body, and that Bo Dukes and Ryan Duke were together when the statement was made, and that they were both laughing amongst themselves. Taking that into account with the other evidence in this case, there is certainly evidence that the jury could find they acted as a party to the crime.
Judge, we don't mind withdrawing 12. It's just, I think it'll confuse the jury. So if party to a crime and knowledge go hand in hand, we're fine withdrawing knowledge.
Judge, we would actually ask the court to give both, I think. And I don't believe I included it in my written charge, but I am now orally requesting that 1.4210 and 1.4211 be given, and I think it would then be appropriate to give the knowledge charge.
Go ahead and take a look at those two, please, Ms. Merchant, 142.10 and 11. Any other thoughts on parties to the crime, failure to prosecute the principal, and knowledge?
I don't think it applies, the party to a crime, and we're fine without that, taking out the knowledge. I just think it would confuse the jury, and there's no evidence to support that. A hearsay statement that someone said after the fact is not enough to support party to a crime theory.
It's a very reasonable thing for the jury to wonder about, even though there's only the one defendant in this case. I intend to charge 4210, 11 in knowledge. If y'all see something tonight, if you're looking over anything, and any cases you want me to review about that, I will be glad to reconsider. But I'm going to give that over the defendant's objection. All right, that's 30. Mere presence and mere association. I typically give those all the time. Ms. Hart?
No objection.
Any objection to those? I don't know that I had plugged them in. I think I just had them sitting there on the bottom of the last page. They should be precisely out of the pattern, and I'll double check that. And please, if you see anything wrong, let me know. But I give defendant's requests 31 and 32. Statute of limitations or defendant's request 33.
We also have this request, Judge.
And 34, you have that too?
I just did it as a specific request. It's our specific request 1 and 2.
Okay.
And 3, actually.
Please take a look, 1, 2, and 3. Please take a look at the way it is presented in the draft. Yeah, on page 8, thank you. I think that covers all of it. Does that suit the state as it's drafted now, and 12 on page 8?
So Judge, my only concern with it, and I actually like the language you used better than what I took from the pattern, but as to the third paragraph, in that statute of limitations under number 12, where it says any period of time during which the evidence shows the person committing the crime was unknown, that is not how it was alleged in the indictment. It was alleged specifically, the second part of that, which is the crime itself was unknown.
Shows that the crime itself was unknown?
Yes, sir. So I would just ask that it conform to the indictment.
Take out the part about that the person committing the crime was unknown.
Yes, sir.
Is that what you're saying?
That's fine with us.
All right, that third paragraph, for any period of time during which the evidence shows that the crime itself was unknown.
Otherwise, we don't have any objections, Judge.
All right, anything further on the statute of limitations part, Ms. Merchant?
No, Judge.
All right, the verdict form is 14 in the draft on page. And I'll just tell you, I typically don't read every one of those. I'll have it in the draft like this to send out with the jury, but I'll just go over the verdict form as to the first count, typically is what I do, and then tell them to apply that analysis to every count in the indictment.
I know how Your Honor does it. I'm satisfied.
And your boxes, you have the boxes next to it where...
I'm talking about in the charge right now.
Oh, in the charge. Okay, I thought you were actually talking about the form. I was trying to follow it.
Well,
Okay.
do you have a copy of the form? I have it. Hang on, let me print that out now, too.
Oh, that'd be great.
Thought I'd already given it to you.
I don't believe, unless it was with that email I missed it, I don't think we have it
That's
at all.
my fault. That's my fault. Must have been understated. All right, Ms. Forshee, are you? There you are. I need you to bring your chair right. All right, we need 2 of these, Ms. Forshee. They need them. What's your list? Oh, you're fine. Any objection?
Yes, we did not go to Chicago.
I get that. Do you care?
Judge,
We have no objection to it.
I'll invert.
Thank you.
All right, so noted. I'll make that change. Next, let's see. Still on yours, Ms. Merchant. No need for the lesser. What about 38? You want to
No, we don't need that.
withdraw that? All right, 39, court's lack of interest in the case.
I think you have that early on.
Yeah, it's in the on the last, page 13. Nothing I did during the progress of the trial was intended to express any opinion about the facts of the case, credibility of any witness upon the evidence, or the guilt or innocence. My interest is that the case be fairly tried according to law, and that you as honest, conscientious, and impartial jurors consider the case as the court has instructed you, and return a verdict speaks the truth as you find the truth of the case to be. Is that acceptable?
Yes, Your Honor. Yes, Judge.
39, then deliberations is part of that section on page 13. Your request 40 unanimous verdict is in there too. That's request 41. 42 is in there as well. If you'll double check those, please, Ms. Merchant. Make sure those are like you want.
I don't think the retired to the jury room is in here, but I don't have strong feelings on that one way or another.
It probably, you may
It
have
might be somewhere else, I just may be missing it.
I'll put it in.
Okay, thank you.
Number 42. All right, on both lists now, I'm down to the specific charges. Is that consistent with where you are?
Yes, Your Honor. Yes, Judge. Well, there was one that was skipped, but I can go back.
Yeah, please, let's go back. Sorry.
Our number 2 commission, I don't believe that was in there. I may have missed it.
Well, it needs to be in there. I think I've given that every single time. Thank y'all.
Thank you.
I'm assuming you're going to take out one of your number 12s, the defendant's choice not to testify?
I am.
Okay.
All right. Back on the state side, the malice murder charge looks like you're proposing is a 2005 version.
Yes, Your Honor.
It is different now. What's your reaction to that?
Judge, I think you should give the current charge. And so it's my understanding that the things that are different are the second paragraph at the top of page 9 is to be murder, the killing must have been done with malice. That is not in the state's charge. And then also The current one says malice may be implied, and the state says malice shall be implied. I think malice may be implied is the appropriate charge.
Where did you get this charge?
I copied it, it's not a charge, it's directly from the
The old
statutes of '05, which is what he's charged with, and to charge the jury on anything different than the 2005 malice murder would be error, and it would be charging him with something that was not a crime or charging him with a different crime than what he's charged with. But I copied and pasted that from the 2005 version of malice murder.
All right, Ms. Merchant, don't you think it's appropriate to do the 2005 version?
Judge, I think it's appropriate to do, because we're following a pattern charge, and the pattern charges are updated when new case law comes out. And so just like we're following the rules of evidence and the case law as of today, for confrontation, for example, we're not following where the law was in 2005. We're following where it is now. Pattern charges are not the statute. We don't just cite the statute. We cite different things than the statute. It's based on case law also. So I think the appropriate charge is the current pattern. It doesn't change the crime.
Have you compared the 05 version of the murder statute to the current murder statute?
Not recently, but I can do that right now, Judge. I did do that back in 2017 when we indicted the case. And I can go to, while I'm looking this up, I can go and tell you that my concern is, yes, as it relates to evidence law, it applies for when you're trying the case, but whether or not the crime was more stringent for the state to prove or less, charging him and telling the jury he's charged with a crime that didn't exist in '05 is an ex post facto law, where we'd be prosecuting him for the wrong crime. But I'm pulling up that statute, Judge.
Let me grab Title 16.
Would you like me, sorry, Judge, I have it. It's a show.
You have the 05 version, right?
Yes, I do. It's copied and pasted into my request.
All right, you're saying this is the specific...
Is copy and paste.
If it's the same statute in 05 as it is now, why shouldn't we do what Ms. Merchant suggests as far as the pattern charge? I mean,
there is no ex post facto problem if it's the. I mean, she's asking for it, I don't think it, well, maybe on an ineffective, but they're not ineffective.
Well, I don't disagree, they're not effective, but obviously.
All right, let me pull it up to you, I'll look at it.
Yeah, so it's actually suggested.
Now, this is one of McBurney's new charges, I think.
Was recommending taking out the last two paragraphs, but
You may find,
you know that proof murder.
that's in it. That's in it.
That's in it now. I think that was one of the things he was talking about.
Yes, Your Honor, I'm looking at it right now. So,
I just don't see any problem at all. If it's the same statute in 05 as it is now. Okay?
I mean, no objection, I guess, obviously, fine, but we don't object to that. Like I said, I was just trying to make sure there's not a problem there.
Check that against the pattern and do it precisely as it is. All right, next. You got the 05 statute? Can you pull that up for felony murder?
That's also copy and paste of it, yes, sir, I can.
C.
It's the same, Judge, in 05.
All right, but now they've added this causation. Right. All right, any objection to that? I think you both asked for that, didn't you? The causation. After the definition, you may find, I think I've got it in there already. All right. Let's take a look at, please, the aggravated assault, burglary, and concealing the death of another.
Sorry, Judge, before we move on from we can come back if we need to. It's in the same portion of the pattern.
It's in there.
It's in there, okay.
The last two paragraphs, please take a look at those. Let's talk about it
perfect.
now.
Okay, I see it now, Judge. Sorry, I just missed it. Thank you.
All right, y'all take a look at the aggravated assault, burglary, and concealing the death of another.
Burglary obviously has definitely changed.
Right.
Aggravated assault, Judge, I believe this portion of the aggravated assault statute has not changed. They did add strangulation, but I do not believe that 65, but I'm going to pull it up just to make sure.
Mr. Merchant's getting me the indictment. I wanted to see how it was phrased for aggravated assault, sorry.
Problem.
But I agree, they added strangulation, that's a big change, but it's got to track however it's indicted.
We'll take a look at it.
Thank you. And I can tell you again, it's
I
copied and
intended to track
pasted.
the indictment, anyway.
Apologies. It's copied and pasted. What is in my aggravated assault request to charge, number 6, is copied and pasted from the 05 version, related to what's narrated to what we indicted.
All right, state doesn't want a lesser included on the malice, I don't guess. You got the felony murder.
No, Your Honor.
All right, simple assault, simple assault. All right, is that language still the same in the new or most recent version of the aggravated assault statute? The part you charge, subsection 2, I guess, right?
Yes, Your Honor. Yes, Your Honor.
Okay.
And the indictment,
I've got the indictment.
you got indictment correct? Okay.
With his hand, an object when used offensively against a person did result in serious bodily injury by using his hand to kill, tear, fray, against. That should be the way I put it in there.
So Judge, in the way that you have it,
No, it says
sorry.
deadly weapon is subsection 2. All right, go ahead. 3.
So, the way you have it in that first paragraph, this is a proper statement of the law. However, given how it's charged, it just causes me some concern. Where it says to prove assault, the person does not have to prove that the other person was actually injured. That is a correct statement of the law. However, because of the way that we charge the aggravated assault, they are actually required to find that it caused serious bodily injury. I just don't want them to get confused between those two. I agree, Judge. That was the sentence that prompted me to ask Mr. Merchant to go get me the indictment.
Good, thank y'all. All right, so we'll take out, all right, for aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon and must prove the defendant attempted to cause a violent injury to the person.
So, actually, Judge, I think because we're taking out the second sentence, the third sentence should come out as well. Those are actually alternative ways of committing assault.
But that isn't that the way you charged it? The violent? Hang on.
No, Your Honor. No, they only charged it the first sentence.
All right, what about the second paragraph then?
No objection from the state to the second paragraph.
All right, Ms. Merchant, we're talking about then for aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon
And then just going straight into the second paragraph at the top of page 10, any objection?
No, I think it's appropriate.
All right, thank you. All right, the burglary count is next.
I think it's appropriate.
And that has significantly changed, as you say, Ms. Hart. Any objection to 5 burglary
No, no
definition? Ms. Hart?
No, Your Honor.
That's right out of, and count 6, any objection as it's drafted here?
No, sir.
All right, didn't you have a couple of specific requests? Let's see, Ms. Merchant, that we hadn't gotten to, I guess not, okay. Do y'all think there's any charge that needs to be made out of Mr. Duke's appearance and his taking of the oath?
I can't think of any.
I mean,
Just the traditional witness ones that we've got.
yeah.
I would ask, sorry, may I, Judge? I would ask the court to give some of the language from the sweat related to that, essentially that there should be no presumption of anything one way or the other, and I'll have to pull up.
That was just back before, when we didn't tell juries a lot of things we should have told them. I mean, it should be up to them. I get the part about what the appellate court was concerned about, but I still think, and that's why I had him come in, it's their case, it's y'all's case. And they need that information, as far as I'm concerned. As far as what the appellate courts at that time were thinking could lead to such confusion on the jury's part, if you want to draft something up and have it in the morning, I'll look at it. I'm not saying I'm going to give anything. That's what I was thinking. I just think that if it'll give them some help about it, I don't mind doing that. And the only thing I consider was telling them about them, don't worry about it. Everybody has the right to take the fifth. And you shouldn't draw any inferences outside of that.
Yes, Your Honor.
Outside of the exercise of someone's constitutional right.
And I wasn't inclined to re-argue sweat issue. I just wanted to say that I would ask for some sort of charge related to that. And I'll send that tonight.
Please, be sure to send one to Ms. Merchant.
Is it possible if there is going to be one presented, we could get it tonight by like 9 o'clock? I go to bed. Thank you.
I do too. Except when I get stuff from him.
Oh, yeah, he doesn't go to bed.
No, he's up. All right. What else can y'all think of?
Judge, we actually had another request to charge related to intoxication, voluntary being no excuse.
Involuntary intoxication?
Involuntary intoxication.
Or voluntary?
Voluntary
Not
intoxication.
an excuse. Did I not have that in?
We didn't talk about it, and I don't believe I saw it in there, but we would request that.
Judge, we have to admit the crime in order to get that? Like, if we admit the crime and say that he did it, but he was intoxicated, then they're entitled to that. But that's not what we have here.
He did admit it in his confession. And during his confession, I understand they're saying it's a false confession, but during the confession, which is played to the jury and they have the right to consider, he specifically indicated he was high and drunk when he committed the crime. And so I think it would be appropriate for the jury to understand that if they decide to believe what he said back in 2017, that is not an excuse. I understand they're not going to argue that, but that's the law.
Is that what you were expecting to hear, Ms. Merchant?
No, it wasn't in the written charges, so I wasn't expecting it at all.
It was in my request.
It's in your request. All right, I'll charge that over objection. I think that'd be appropriate because of the statement that came in. All right. As far as the arguments go, do you know, Ms. Hart, if you and Mr. Rigby would split it up, or I don't have any problem if all three, you know, if everybody wants to take a topic or a portion of the argument?
We do not intend to split it, Judge, and in fact, there's a statute on point that says that that's not allowed. I had this come up recently, and I think it may say if they intended to do, if we intend to do that, we have to give notice. Don't quote me on that last part, but there's a very specific statute on point that goes against that, and we do not intend to split it.
Do you object, I guess? If they...
We would, yes.
Judge, I think the statute she's referring to is 17870 in criminal cases, except by express leave of court, no more than 2 counsel may argue in closing for each side, and only 1 counsel may make the concluding or rebuttal argument. So 2 lawyers can argue the closing.
Do you agree with my discretion?
I have to take again, it's been several months since I had this come up, so I have to take a look at that specific statute, but I didn't know they were going to attempt to do that, and we were going to discuss it, but, and I'm looking at sweat, but certainly I can try to do that.
Take a look at that, and I'm going to allow it, if it's within my discretion to do so, for the defense.
Is that as to all 3?
No, up to 2. Do you intend to make some opening remarks as far as your closing goes, and then sit down and then come back?
Mr. Rigby's actually going to do the closing argument.
Okay, sorry.
I don't know the answer to that, but normally he does not. Normally he just reserves.
Okay. So y'all will be up first, if the regular pattern holds. Anything else?
Not from the defense, Judge.
There you go.
Listen, thank y'all. Y'all have done a great job for both sides of this case, and I'll see you in the morning, 9 o'clock.
Is it possible to get an email of your the final one? Okay.
And I'll send it out to you before I leave.
One other issue, Judge, this came up during the questioning of Mr. Duke by the state on the issue of statute of limitations in Ben Hill County. He was asked about that, and he specifically said, I've got no knowledge about that.
Right.
So there's no evidence of that in the case, so we want to make sure that the state is not referring a closing argument to a statute of limitations issue in Ben Hill County.
It's the law. We can certainly argue the law. Whether he knows it or not is not what would be argued. It's the fact that he can't be charged in Ben Hill County. That's a proper statement of the law. Nothing.
And I allowed him to answer it if he knew, and he said he didn't know. Never been discussed, right?
What he claims, yes, sir.
And Judge, there's just been no factual evidence, testimony or otherwise, that relates to the statute of limitations issue in Ben Hill County, other than what they have put up in terms of the searches. So I don't know, the jury's going to be very confused at best about what to do with that information once they get it from the state, because there's not going to be anything in the jury charge about it, and there's not going to be any evidence about it.
All right, Mr. Rigby had to leave.
He did, but Judge, the court is actually going to charge them that as to concealing a death in Ben Hill County, that there's a 4-year statute of limitations. If there's confusion caused by that, then we're stuck with that.
Well, the confusion is the Ben Hill County part. I'll charge them there's a 4-year statute of limitations on this charge. Right?
Oh, I agree, Judge, but what they're trying to say then is that we can't argue that there's also a 4-year statute of limitations in Ben Hill County. That, and again, I don't know if he intends to do it, but that is a proper statement of the law. Whether or not he knows that or not, it is not what would be argued.
He's not been charged in Ben Hill County with anything, correct? Mr. Duke?
He is not, no, sir.
Right.
But the jury doesn't know that. That's not information from the jury.
I'll probably, we'll talk to Mr. Rigby and see what his thoughts are, but I'll probably not allow that. Okay. All right. Hopefully right now y'all have this, and if you see any errors I'm liable to make, please just let me know.
Thank you, Judge.
If something comes up overnight, we'll talk about it in the morning, okay?
Have a great night.
Thank you.
Y'all have a good night.